in his campaign in 1968, Nixon appealed to voters for their support in these words: America is in trouble today, not because her people have failed, but because her leaders have failed. Let us begin by committing ourselves to the truth, to see it like it is, and to tell it like it is, to find the truth, to speak the truth, and to live the truth. Now, you have any reason to think that between that time and 1972 that President Nixon had changed his position, his fidelity to the truth?
I have no doubt whatsoever that his fidelity to the truth is the same as it was in '68.
And yet he said that the way to save America in 1968 was to find the truth, to speak the truth, and to live the truth. And yet when 1972 came and these White House horrors became known to you, you didn't take the advice that President Nixon gave us all in 1968, did you?
Not under that particular guideline, I assure you.
In the Senate of the United States, a resolution to establish a select committee of the Senate to conduct an investigation and study of the extent, if any, to which illegal, improper, or unethical activities were engaged in by any persons, acting individually or in combination with others, in the presidential election of 1972, or any campaign, canvass, or other activity related to it.
From Washington, NPAC brings you gavel-to-gavel videotape coverage of today's hearings by the Senate Select Committee on Presidential Campaign Activities. Here is NPAC senior correspondent Robert McNeil.
Good evening. The puzzling political and ethical philosophy of John Newton Mitchell got a second national airing today and appeared to leave the Watergate committee skeptical and frustrated. Under 5 hours of cross-examination, the former Attorney General and Nixon intimate elaborated on his firm conviction that the re-election of Richard Nixon transcended all other considerations last year. That was his rationale for telling the president nothing that he knew about the Watergate break-in or cover-up. Coupled with Mitchell's adamant claim of his own innocence in all these matters came a long list of confessions that, in hindsight, he should have done this or that, should have kicked Liddy out of his office, should have made his opposition to the bugging plan more obvious, should have told the president at various times, should have told authorities what he knew about the Ellsberg psychiatrist burglary. Mitchell was to have finished today, but the committee will bring him back tomorrow for a final attempt to sift through the litter of inconsistencies and, in the eyes of some members, improbabilities left behind by 2 days of his testimony.
If you stay with it to the very end tonight, you're going to hear a very interesting comment by John Mitchell in which he says, quote, a great trial they're conducting up here. And he says that offhand to his lawyer, just as Senator Ervin has adjourned the hearing session. David Epstein, an adjunct professor of law at the Georgetown University Law Center here in Washington, a former prosecutor, is with us. I want to ask him, is this in fact a trial?
Yes and no. The questioning by Senator Inouye and Senator Montoya, it goes into the detail, into the progression of events. That's perfectly proper at a trial. The questioning by Senator Baker goes into Mr. Mitchell's motive. That's perfectly proper at a trial. Much of Senator Ervin's question has to do with matters that Mr. Mitchell's really not in a position to testify. Senator Ervin's trying to get a message to the president. That's irrelevant. That wouldn't be allowed in at a trial. And Senator Weicker, much of his questioning gets into arguing with the witness. That wouldn't be allowed into, at a trial. So in the sense of questioning as to motive and details, the answer is yes. In the questioning as to that's irrelevant or argument, the answer is no.
Okay, thank you, Mr. Epstein. Of course, then the question in human terms of the use of the word trial, you can see for yourself and make your own decision. We will be back with Mr. Epstein. He will be joined by Stephen Hess for further discussion at the close of tonight's broadcast.
Today was a grueling one for John Mitchell as he answered or fended off questions from 5 of the committee's 7 senators. As we do before each playback of the hearings, here is NPAC's hour-by-hour viewing guide. In the opening hour, Mitchell is questioned about his silence with President Nixon. Mitchell says the president's isolation did not keep him from doing his duties, adding, "The president is never above the laws of the land." He adds that despite the current controversy, the president's good name would be protected by the facts as they come out. In hour number 2, Mitchell concedes that if the so-called White House horrors were revealed to the American people, it would have had an adverse effect on Nixon's re-election bid. And under tough questioning from Senator Baker, Mitchell says flatly that not informing the president was a mistake. In the third hour, Mitchell is asked about his meetings with Gordon Liddy. He maintained steadfastly he disapproved of all Liddy's bugging plans. Asked what he told President Nixon following the Watergate arrests, Mitchell says, "I apologized for not having better control over the campaign workers involved." In the fourth hour, Mitchell is asked why he did not inform the president once the election was safely won. He replies, "It was not my responsibility. Others in the White House were in charge." Mitchell is asked if he would lie to protect the president. He says no, adding he doesn't have to. In the final hour, Mitchell says that in meetings after the break-in, there was no talk of destroying documents. Pressed about the break-in at Daniel Ellsberg's psychiatrist's, Mitchell says it produced nothing. Well, now to the hearings themselves. As Senator Ervin, the committee chairman, brought the proceedings to order this morning.
The committee will come to order. Ed, I believe you'd finished. Yeah. Senator Norrie.
Thank you very much, Mr. Chairman. Mr. Mitchell, throughout these many days, witnesses have testified as to hundreds of meetings held along the George Washington Parkway, meetings held in hotel rooms. I believe there are 3 meetings of special significance. One, the meeting of January 27th, the other of February the 4th, and the third, February the 30th, March the 30th, all occurring prior to the June 17th break-in. Witnesses have testified that at the first of these meetings, criminal activities were discussed, to wit, the kidnapping of leaders of dissident groups and hiding them away in Mexico, the leasing of a yacht, and fitting the facility with special photographic and eavesdropping equipment, and servicing this yacht with prostitutes to entice leaders of the opposition and to place them in compromising positions, and the breaking and entering to photograph documents and engaging in electronic surveillance. And I gather that at the first meeting you had, in addition to the Attorney General of the United States, Mr. Magruder, the Deputy Chairman of the Committee to Re-elect the President, the Counsel for the President of the United States, Mr. John Dean, and Mr. Liddy, the Counsel to the Committee to Re-elect the President. And yesterday, when asked about the price tag, your response was, "Oh, just $1 million." At the close of that first meeting, you testified that you told Mr. Liddy to, quote, "take that stuff out and burn it." At the second meeting on February the 4th, this was also in the office of the Attorney General. In addition to the Attorney General, Mr. Magruder, Mr. Liddy, and Mr. Dean were in attendance. And at this time, we had a scaled-down plan costing about $500,000. And at the close of this meeting, Mr. Dean was quoted to have said, "We should not be discussing this in the Attorney General's office." Would I be proper in translating your statement, "take that stuff out and burn it," to mean get rid of this incriminating evidence? Not only that, Senator, to get rid of the incriminating evidence, but also to abandon any concept that
any such activities would be part of the re-election campaign of the president.
Did you advise the participants that they were essentially participating in a conspiracy to commit a crime?
Not at that time, no, sir, I did not.
I ask this because just about that time, your office, with much publicity and great vigor, had pursued the indictment of American citizens who had allegedly discussed the kidnapping of Dr. Kissinger. Is there any difference between the discussion of a kidnapping and the discussion of these criminal activities in your office?
Senator, I think you've stopped very far short in connection with the activities of the indictment that you referred to. There were overt acts in connection with that as well as discussions.
Wasn't there any overt action in this case? There were 3 meetings, charts that cost a small fortune.
Those were not the type of overt acts that were involved in connection with the indictments that you referred to.
Why did you not, as the Attorney General of the United States, advise the President of these meetings?
For the very simple reason that I presumed and had every reason to believe that these matters were over and done with, were through, and that was the end of them. The President of the United States has many other things to concern himself with other than the type of factor that were involved in these meetings and many other meetings.
Weren't you concerned when they persisted?
I'm not sure I understand your question, Senator.
You had a meeting on the 27th of January, February the 4th, and March the 30th. Didn't you consider that this was nothing frivolous?
Well, to my mind, the matter had not been approved. It was not going to be approved, and that was the end of it. There are many, many things happen in connection with a political campaign that you do not go and advise the President with respect to. The obligation rests upon those that are conducting a campaign and not the President to follow each and every one of the details.
In your colloquy with Senator Talmadge, you indicated that the election of the President was so important that you did not wish to advise the President of the White House horror stories because he might blow the lid off and thereby endanger the election.
I think that is a reasonable summary of it. I don't think I used the word blow the lid off, but that he would take very, very strong action that would put the...
He would lower the boom on people.
That's, I think, was my phrase, and I'm sure that would have been the case.
Why did you not advise the President in November of 1972, or December of 1972, or January?
That, in my opinion, was the election was over. There was going to be a house cleaning. The matter would have taken care of itself at that particular time.
As one who was aware of the facts, didn't you think that as the President's confidant, it was an obligation on your part to advise the President?
Well, there are different types of obligations, Senator, and I think in my particular case, I have always looked upon it as my obligation being that which was in the interest of the President. And I did not believe or feel at that particular time that it was necessary that he be so advised that these matters come out to the detriment of his second term. It was my full belief that he was going to take care of the reorientation of the White House, and the matter would be taken care of by itself.
I'm certain, Mr. Mitchell, you've heard of the famous memo prepared by Mr. Buzzard.
The one that the Senator read?
Yes, sir.
I have a slight knowledge of it.
In this memo, Mr. Buzzard suggested that based upon the information made available to your successor, Mr. Kleindienst, he stated in late July of 1972 that, quote, "It did not appear that any White House people or any high-ranking committee people were involved in the preparation of planning or execution of the break-in." The White House memo goes on to note that, quote, "History fails to record that at that moment Dean corrected the Attorney General's erroneous impression by pointing out that Mitchell, Magruder, and Dean had all been involved in planning of operations of which Watergate was the obvious derivative, or that Strawn had knowledge of the fruits of this kind of operation, or that all of them were suborning perjury and otherwise seeking to conceal the facts." End quote. The memo goes on to fix Dean with the principal blame for, and I quote, "the political and constitutional crisis that Watergate now epitomizes." End quote. Such blame as a senior and as a man whose counsel and advised the President of the United States sought with much greater frequency and respect would seem to share in at least equal proportion. And that memo goes on to say, quote, "It would have been embarrassing to the President if the true facts had been known shortly after June 17th, but it is the kind of embarrassment that an immensely popular President could have easily weathered. The political problem has been magnified 1,000-fold because the truth is coming to light so belatedly, because of insinuations that the White House was a party to the cover-up, and above all because the White House was led to say things about Watergate that have been since found to have been untrue. Do you still maintain that you served your President and your nation well by the course you pursued?"
Senator, I don't know whether you're adopting Mr. Buzzard's premises or not. I certainly do not adopt them. Furthermore, as I listened to your reading of that particular paragraph, it relates solely to Watergate. My reasons, my motives had to do with an entirely different subject matter, and that had to do with the White House horror stories, not the Watergate.
Well, Mr. Mitchell, if the re-election of President Nixon was so important that you were willing to engage in activities which can be well described as being irregular to ensure his re-election, I think a question lies in many minds at this time. To what length are you now willing to go to deceive an effort to avoid further implication of the President in the activities under investigation by this panel? More specifically, are you willing to lie to protect the President?
Senator, there is one great thing about the answer that I can give to that question to you. I don't have to make that choice because, to my knowledge, the President was not knowledgeable certainly about the Watergate or certainly knowledgeable about anything that had to do with the cover-up, if that's the phrase that we are using. So I don't have to make that choice.
In your testimony, Mr. Mitchell, you've suggested that it would not be fair, that's the word you've used, fair to the President, if the facts relating to Watergate and the White House horrors had been brought to his attention and to the attention of the American people during the election campaign. Have you ever considered whether it was fair to the members of the opposition party or fair to the American people to conspire to keep them from the true facts of this matter?
Yes, I'm sure that subject matter has crossed my mind many, many times. But I do not believe now, I did not believe then, that the President should be charged with the transgressions of others. And it's just as simple as that.
What was wrong with telling the people of the United States the facts involved, as you knew them as Attorney General?
As Attorney General?
Or as the chairman of the committee to re-elect the President?
The campaign director?
Yes.
It was the fact that, as you know, are very well aware of, Senator, these matters are imputed, of course, to the highest authority, regardless from where they arise. And it was my opinion that he would be improperly associated with these activities.
I'm reminded that as Attorney General, like all public officials, you are required to take an oath of office to uphold the Constitution of the United States. And I'm reminded by telegrams that I've been receiving that this is a government of laws and not of men. Did you feel that the President was above the laws of the land?
The President is never above the laws of the land, and to my knowledge, he has faithfully executed the laws of the land.
Did you think that in your execution of the laws of the land and the upholding of the Constitution, you had an obligation to advise the President of these irregularities?
At what time and what time frame are you talking about, Senator?
The meetings of February 27th, the meetings of February the 4th, and March the 30th?
Well, of course, on March the 30th, I was not in public office. With respect to the prior ones, the discussions did not go to the point where I thought it was of a requisite nature that anybody be advised of them because of the actions that I took with respect to them.
In your discussion with Mr. Dash, you said the following, and speaking of the President, and I believe this is rather important. What I'm saying is that I think I know the individual. I know his reaction to things, and I have a very strong feeling that during the period of time in which I was in association with him and did talk to him on the telephone, that I just do not believe that he had that information or had that knowledge. Otherwise, I think the type of conversations we had would have brought it out. Mr. Dash, generally, is it fair to say that much of your opinion that you express is based on your faith in the President and your knowledge of the man, rather than any specific statement the President made to you or that you made to the President, Mr. Mitchell? Well, I subscribe to the first two. I do have faith in the President, and I do think I have knowledge of the man, and I do think there are enough discussions in that area, in the general area, to the point where I think the general subject matter would have come out if the President had had knowledge. And this is very important because based upon your knowledge of the President and as a judge of men and men's character, you are suggesting to this committee and to the people of the United States that the President was not aware of the break-in and of the cover-up that followed. In your position as Attorney General, like all of us in public office, we are called upon to hire people or to get ourselves involved in the process of hiring people. I note that you have hired or was involved in the process of hiring very important men. Jeb Magruder, John Dean, Frederick LaRue, Mr. Mardian, Mr. G. Gordon Liddy, and Major General Turner. And I note that there's one thing in common with all of these men. They've all been involved in the commission of a crime. Would you say that you're a good judge of character, sir?
If the senator wants to go back over that list, I will discuss them item by item. Number one, with respect to Mr. Dean, I did not hire him. Mr. Kleindienst did as the Deputy Attorney General. I would fully subscribe to his hiring him at that particular time. As Mr. Dean has testified, I advised him to stay in the Justice Department, not to go to the White House. With respect to Mr. Liddy, if you would take and look at his record and background to the date upon which his hiring was discussed with me by Mr. Dean, he had an impeccable record. With respect to General Turner, he probably had the finest record with respect to his activities to the date of his hiring as the Chief Marshal that anybody could possibly have. He had more citations. He was better known for his activities in connection with demonstrations and sabotage. We were depoliticizing the Marshal Service. Here was a man with an impeccable Army record. Have I missed somebody? Mr. Magruder, of course, was recommended from the White House and perfectly acceptable to me at that particular time. So that if you look at the backgrounds of these individuals to the time that they came into the picture, so far as I was concerned, they all had impeccable records.
And you did not at any time note any flaw in them?
I was not aware of any, of course.
Throughout your testimony, you have responded to questions by using the word hindsight, that by hindsight you may have done otherwise. What advice would you give to your successor so that he would not repeat some of the errors you have made, which you admit by hindsight?
Well, needless to say, Senator, I haven't really given a great deal of thought as to that particular subject matter, but there's one item that keeps coming to the fore all of the time, and I presume you're talking about a political campaign. There is one thought that keeps coming to the fore all the time in my mind, and it particularly relates to what happened in the campaign for the re-election of the president. A campaign is a most unique operation. It builds up in a very short time to a crescendo, and then, of course, it's terminated and the organization and its activities are abolished. I would think that the one thing that has stuck in my mind very clearly, and that is that instead of having one individual as a campaign director that can't keep his hands on the pulse of everything that's going on, that there ought to be much clearer lines of authority and responsibility so that it is compartmentalized to the point where you can keep your hands on things and that you can have somebody in charge of a particular segment of it, and that those people do have a greater responsibility instead of bucking everything up to the top, whether it be by option memos or whatever it is. Because you're dealing with people, you're dealing in a highly charged emotional area, and to me that's the one thing that I can think of right off the bat that should be done in connection with political campaigns.
As the former Chief Law Officer of the United States, would you care to recommend to this committee any legislation to prevent the reoccurrence of some of the irregularities that occurred in the 1972 presidential election?
Senator, I would be delighted to do that, but I would like to give it more thought and a little bit more study. I've noticed that one of the committees of the Senate is already hacking away at the election law in areas that deserve consideration, which were one of the problem areas that we had to consider. I think this is something that needs a great deal of thought and can't be expressed at a time like this when other matters are on the table, but I would be delighted to provide you with my thoughts on the subject matter.
As director of the campaign, on March the 1st, I believe that's the date you assumed the position?
No, sir, it was not. The date that I formally assumed the responsibilities as campaign director was April 9th.
April 9th. On that date, were you concerned about the nomination of Richard Nixon?
I think you always have to have a concern, Senator, regardless of the fact that you have an incumbency. You still had two opponents, one on the, shall we say, the spectrum of the left, one on the spectrum of the right. You have a long way to go between then and the nomination. I think that you always have to have a concern.
My final question, sir, and that is the general question of executive privilege. As a former Attorney General of the United States, could you advise this committee as to your thoughts on executive privilege?
Well, my position has been, and I must admit in some of the appearances before the Judiciary Committee that the chairman and I have not always agreed, that the President has very wide-ranging powers in this particular field. But I believe there's also testimony in this record coming from Mr. Dean to the effect that I was out in front recommending that the President not invoke it in connection with the hearings that this committee is undertaking. I felt that the President was being ill-served by the thought that he would invoke executive privilege with respect to this committee, even though he might have the constitutional power to do so.
To be more specific, it has been reported in the press that Mr. Ehrlichman, when asked a question, did you notify the President as to the Watergate break-in, his response was executive privilege. Do you think that executive privilege goes that far?
If I understand you, that Mr. Ehrlichman was asked a question about the subject matter,
as to whether he advised the President of the United States as to the Watergate break-in, and his response was, I do not wish to discuss this matter because of executive privilege.
Senator, in my understanding of executive privilege, it's not Mr. Ehrlichman that can invoke it. It's the President is the only one that can invoke the area of executive privilege.
As the Chief Law Officer of the United States, do you see a distinction between the activities of the President of the United States and a person running for re-election to the presidency of the United States?
Well, it depends on the area, of course, in which we're...
Let us assume that we have papers, presidential papers, papers involving the presidency of the United States and papers involving efforts to re-elect this person. Should all of these papers be bunched into one category of presidential papers?
Well, it depends entirely on the nature and the contents of the papers, and if they are the President's papers, and I have testified before the Senate Judiciary Committee on my opinion with respect to this, the President has an absolute power of executive privilege, that his power extends to that area. Now, if we're talking about papers that do not involve the President, that are collateral to him, staff papers, that's an entirely different subject matter.
What if these papers recommend or suggest the commission of crimes?
Now, what papers are we talking about, Senator?
Papers that are now in the White House.
Papers that went to the President?
Memos that were prepared by staff members addressed to the President of the United States.
That recommended commissions of crimes?
Yes, sir.
I would doubt that such papers would exist. But if they're talking about staff papers, I think it's an entirely different matter with respect to what we are talking about as presidential executive privilege.
Would you consider the involvement of the CIA in domestic affairs as being within the laws of the United States?
Well, that is a very, very broad question, Senator, that can't
I'm certain you're aware of the so-called Dean papers.
There are so many Dean papers that I think we ought to be a little bit more specific.
These are the memorandums describing the formation of an extra-legal intelligence organization in which you were involved?
Now, are you talking about what we discussed yesterday as the Houston papers?
Yes, sir.
Not the Dean papers, as such.
We call them Dean papers because he collected all of these papers.
Well, I just want to make sure we're talking about the same...
The Houston papers, yes.
Same documents. Senator, there has been a necessity in this country from the time that the FBI and the CIA were created, in my opinion, that there be liaison and coordination among those agencies as well as others in this government. It does not necessarily imply that the CIA have an operative action or an operative base within the United States, which is prohibited by the statute. But if we are to get the benefit out of the intelligence that the CIA has and the FBI has and the DIA has and all of the rest of the agencies, we just have to have communication among those agencies, and as I said yesterday, even more important, an evaluation of the intelligence that they do provide, because there's been too long a practice in this country for one of these agencies to have information about intelligence matters that get into the file in the operative agencies that can carry out a mission to prohibit some of these things, just do not have that information. And I think a good example, without knowing the facts, is the recent assassination of the member of the Israeli embassy here in the District of Columbia. Now, obviously, the greatest amount of intelligence that could possibly come with respect to that matter would be the CIA. And if the CIA were knowledgeable with respect to the individuals that might perpetrate such a crime, they certainly have to pass it on to the FBI and the Washington police in order that proper action can be taken. I use this as a hypothetical case without any specific knowledge.
But then the Houston papers describe something else beyond coordination.
Yes, very much so.
Did it describe the activities of the DIA and the CIA in surveilling citizens, dissident groups, Black Panthers, the Weathermen? We're not talking about foreign enemies.
Well, Senator, as I testified yesterday, I did not study the Houston plan. It was discussed with me, and I saw some of the notes, to my recollection, where Director Hoover objected to it. To the extent that it involved the items that you were talking about, in my opinion, is one of the reasons that it was turned down and not implemented. But I am saying that, and we started this discussion on the basis of CIA and its activities within the country. It has no operational activities and shouldn't have. That's not what it was created for. But there's no rhyme or reason in the world why the intelligence that they have should not be passed on and imparted to the law enforcement or investigative agencies in this country that do have operational responsibilities.
Mr. Mitchell, getting back to the presidential papers, if this committee should decide to issue a subpoena to get these papers, what do you think should be the response of the White House?
Well, I'm afraid you're going to have to ask Mr. Buzzhart that. He seems to be making most of the decisions over there. I have no opinion on the subject matter.
As the former chief law officer, what are your thoughts, sir?
I'm sorry, Senator. Was that a question which you've put to me as a former chief? It would depend entirely upon the nature of the papers, as we discussed before. If they are matters of presidential communications, I think there's an absolute privilege. If they get into collateral areas where the president is not involved, I think that's an entirely different subject matter.
Once again to the Houston papers, you've indicated that your knowledge is limited to a discussion of it, but according to testimony, you had approved it. Did you approve the Houston plan?
No, sir, that's absolutely incorrect. If I may recount what I think the record shows, and certainly what is my recollection, is that with respect to the Houston papers, there were conferences held under the aegis of, I presume, Mr. Houston from the White House, among the heads of the intelligence gathering agencies, the CIA, the FBI, and the DIA, in which resulted in a memorandum that provided for activities with respect to domestic subversives, of course, as well as national security, and involved such things as surreptitious entry of places, mail covers, etc., etc. I was not part of that committee. I had no knowledge of it until it was brought to my attention by the director of the FBI. It was then that the matter was discussed with me. It was then, or shortly thereafter, that the concept was terminated.
Were you aware that the President of the United States approved the Houston plan?
No, sir. I testified yesterday I was not.
Isn't it strange that as the Attorney General and as a participant in the discussions that you were not aware of this?
As a participant in the discussions, I was not a participant in the discussions with respect to the plan. I was a participant in discussions when Mr. Hoover and I believe Mr. Deloche came to me with their concerns about the matter. I was not a participant in the discussions that led to the formulation of the plan.
Did you advise the President of the United States as to your misgivings and reservations?
It is my very strong recollection that I advised Mr. Haldeman and the President after it was brought to my attention by Mr. Deloche and Mr. Hoover.
What is your relationship with Mr. Kalmbach, sir? Do you know him well?
Well, I can't say I know him well. I've known Mr. Kalmbach since 1968 and have seen him infrequently over that period of time. I knew him, of course, in connection with the 1968 campaign. Our contacts between 68 and 70 or 71 have been very infrequent, probably more social than anything else. And, of course, I knew him during the 1971-72 campaign when he was a fundraiser.
Did you have any relationship with him during the month of June? More specifically, 18th, 19th, and 20th of 1972?
Yes, I had a very, very close relationship with Mr. Kalmbach during that particular period of time, because it was during that particular period when I was talking to him daily or perhaps twice a day, because he was kind enough, he along with his wife and the secretaries in his office, to be of great assistance to my wife, who was then out in Newport, and I'm sure you know the rest of the story.
Mr. Mitchell, I believe in response to a press inquiry relating to Mr. McCord, your answer was something to the effect that Mr. McCord has a private business and he has several clients, and your committee was one of the clients. Isn't it true that you were personally acquainted with Mr. McCord?
Well, Senator, you're asking two questions. The press statement that you're talking about was the press statement that I put out when we first found out about the break-in and burglarization of the Democratic National Committee where Mr. McCord was involved. Everything in it was factually true. I had one meeting on the 5th of April with Mr. McCord. Is the only time that I've ever met with the gentleman and talked to him. And that meeting was for the purpose of briefing me as I was coming into my law office, which was in the same building for the committee to re-elect the president, briefing me on the security measures that were being established and to be established in connection with that facility in 1701 Pennsylvania Avenue. That's the only meeting that I've ever had with Mr. McCord in my life. The other times that I've seen Mr. McCord were casual passages when he was in the lobby of 1701, and I think at one time he was in the hallway of the apartment where we live. That's the extent of my contacts with Mr. McCord.
Was Mr. McCord in charge of the providing security for your personal apartment?
No, I don't believe that it could be classified as such. I learned at a later date that Mr. McCord did an electronic sweep of the apartment. At what time frame, I do not know. But there was nobody providing security for the apartment as such.
Was he in charge of the security of your person and the person of your wife?
Not personally. Mr. McCord, with the assistance and help of other individuals, provided people that traveled with my wife and myself when we traveled as security personnel. Mr. McCord, to my knowledge, never traveled with my wife, and I know he never traveled with me.
It's been testified that Mr. McCord occasionally picked up your daughter at school and brought her back to the Watergate apartment.
This could conceivably happen, and I don't know the facts, for a very, very limited period of time, because when we left the Justice Department, I immediately made arrangements to have off-duty marshals take care of the transportation of my daughter, and I have, of course, the statements and bills to show it. So that if this were the case, if Mr. McCord did this, it was for a period of 1 or 2 or whatever days there were in this interim period before these off-duty marshals picked up the task and carried it out.
And my final question, sir, and this goes back to my first question. Why did you not advise the President of these irregularities after the election? And I believe your response was you were confident that the White House would take care of it.
I was quite confident that the White House would take care of the problem, or at least the individuals there, to the point that it wouldn't happen again, that the change of personnel, which was announced, the reduction of the staff, the people that were moving out of the White House that had been participants in these activities, that there was no reason, in my opinion, to cast the pall over the second term of the presidency.
Weren't you concerned when some of the major participants were not being tossed out?
Yes, sir, I was.
Why didn't you tell the President then?
I felt that the majority of them had been removed, and I would have thought that the lessons had been learned.
Mr. Magruder was not removed. Mr. Dean was not removed.
Mr. Magruder was not placed into the White House. Mr. Dean, in my opinion, was not the perpetrator of the White House horrors. To my knowledge, I don't believe Mr. Dean had any hand in it whatsoever.
Was he not a participant?
Mr. Dean,
yes, sir,
in the White House horrors that we've talked about, to my knowledge, he was not.
Was he a participant in the cover-up of the Watergate?
I believe that Mr. Dean was very knowledgeable of the subject matter and participated to the extent that he has testified to.
Don't you think that you had an obligation?
Senator, if I can add an addendum to that, Mr. Dean was at that time looking for other employment and was hopefully going to be able to get out of the White House.
if Mr. Dean was not the perpetrator, who was the perpetrator of the White House horror story?
Well, I believe that the best answers to your question will be those who testified to it and the ones that have testified to it. I read in the newspaper of the affidavits that have been filed in connection with the Ellsberg case and the discussions with respect to the DM papers, the statements that the individuals have made with respect to the Dita Beard matter, et cetera, et cetera. I think that my knowledge is that of one who has received it from some of those that were involved. But I can't give you the chapter and verse as to who were the total number of individuals that were involved in each of these activities.
When did you first learn of the White House horrors?
Well, as I testified yesterday, the first information that I got with respect to them was the debriefing or briefing that Mr. Liddy gave to Mr. Mardian and Mr. LaRue, and subsequent to that time, Mr. Dean imparted a great deal of the knowledge in other areas to me that Mr. Liddy had not provided Mardian or LaRue.
Did the President know of the White House horror at that time?
In my opinion, no. If he had, in my opinion, I think he would have taken some pretty strong action.
Why did you not tell the President?
I think that's the same question that we have answered 3 times this morning, Senator. We are now talking about the end of June. We're talking about the election. We're talking about the campaign.
We're not talking about Watergate. We're talking about the other horror stories.
That's exactly correct. Those are the ones that I'm talking about, which to me were a great deal more damaging to the election than Watergate. Watergate was already out. Watergate was the issue. It was the subject of a suit by the Democrat National Committee. It was constantly in the newspapers. The White House horror stories were not out. They were not under discussion. And these were the things that would have more impact upon the election, in my opinion, than the Watergate matter.
Did you think it was the obligation on the part of the President's 2 closest aides to have advised the President of these horrors, Mr. Haldeman and Mr. Ehrlichman?
Well, I'm afraid I'm going to have to let them talk for themselves, Senator. I don't want to judge what another man should or should not have done.
In your discussions with Mr. Haldeman or Mr. Ehrlichman, did they ever tell you that they advised the President of these horrors?
No, sir, they did not.
Did they ever advise you that the President was informed as to the break-in and the cover-up that followed?
That the President was advised of the break-in? Obviously, he was advised of the break-in. Everybody was that read the newspapers. Now, the second part about it with respect to the cover-up, no, they have never advised me that he was informed of that part of the subject.
Was the President concerned about the fact that checks issued by your committee had found its way into the hands of those who had broken into the Watergate office of the Democratic National Committee?
I would presume that he would be, but I've never discussed the subject matter with him, so I can't give you a first-hand personal report on it.
If these things had been out in the press, didn't you think it was your obligation to fill the President in with the details?
Now, what things are we talking about?
The Watergate, you just said that the press had covered it adequately.
I did not believe, and to this day I believe that I was right in not involving the President in any of these subject matters. Because obviously he would have had to take, as I have testified before, very strong action, which would have been to the great detriment of the campaign that was being run on his behalf.
And in your mind, the campaign was of the utmost importance? the election outcome?
The re-election of the president, this particular president, was upmost in my mind and without question.
And it is your feeling that everything should be done to protect his present administration from further damage?
I don't get the thrust of your question, Senator. Are you talking as of now, as of this date?
Yes, sir.
I think that the current time and the affairs of men are to the point where these stories are now out. They should be fully explored. I think those who are involved should be fully identified, and I think that the appropriate action should be taken, because as of this particular time, there is no rhyme or reason why the circumstances should try to revert back to what they were prior to the election, or even prior to the time that the stories came forth in whatever manner they came forth. I think, however, that great care should be taken to ascertain who was involved and how they were involved, instead of just lumping it into a catchphrase of Watergate or cover-up or things like that. I think it's time that the individual activities be properly parsed out.
You've said on several occasions that if the president had been notified, he would have lowered the boom and have taken drastic steps. And you have also suggested that you know the man very well. What would the president have done if you had notified him of the Watergate and the cover-up?
I'm sure that he would have the... Now, here again, Senator, you're talking about Watergate. Is that what you're talking about?
And the cover-up.
Well, we have to get, I think, more specific in order to discuss these matters in the proper context. Are we talking about what we've now discussed for the last 2 days, the White House horror stories? Are we talking about the Watergate break-in? Are we talking about...
Well, let's say the whole package.
Well, I would believe that the president would have brought in the appropriate governmental officials from the investigative side and from those who were the prosecutors, and laid it all out to them and said, here it is, take it in the proper process of law.
He would have brought the FBI in?
That's the investigative agency that acts on behalf of the federal government, Senator. Yes, sir. And of course, the important thing is to get the facts and make sure of your facts before you go to a prosecutorial aspect of any activity.
What would the president have done if he found out that his choice for the directorship had destroyed evidence?
Well, I'm sure he would have done what he has done since, and that is made sure he was replaced very rapidly by somebody who was not so involved.
Would he have fired Mr. Magruder? Would he have fired Mr. Dean?
I would feel quite certain that would be the case.
And yet these men were not fired after the election.
They were not fired because the president was not aware of any of the activities that they were involved in. After all, with respect to Mr. Dean, the president was unaware of his activities at that time after the election.
With all the cover,
in my opinion. And secondly, as far as Mr. Magruder is concerned, that was at such a lower echelon that I'm sure that the president was not particularly involved in his continuance on the inaugural committee or to whatever governmental job he went to.
with all the headlines and all of the lead articles, the front page articles appearing in the Post, the Times, and other national newspapers, isn't it strange that the President was never concerned to call in the investigatory arm of the federal government to investigate the alleged irregularities being carried out by members of his staff? In these articles, names were named.
Senator, the investigative arm of the federal government, as I think you described it, the FBI, has been investigating this case from June of 1972, and I'm sure their investigation has continued all the way through.
Do you think they did a good job?
I'm not privy to what they did or didn't do. I've heard statements made with respect to the number of investigations, the man-hours, and so forth. I don't know what they did or didn't do.
You've indicated that Mr. Magruder was low on the totem pole, was from the lower echelon. And the fact that he was deputy director of the campaign and had authority to spend unlimited funds, didn't that make him very important?
Senator, we're changing courses here now. I'm just talking about his governmental position the last time. With respect to his activities in the campaign, obviously, he was quite important.
And this is absolutely my last question. I believe that all of us would maintain that we are men of honesty, men of truth, and men of integrity. You've indicated that you have great faith in the President and that his administration is of utmost importance. To what extent would you go to protect the good name of the President?
Senator, I think I answered that same question in another form previously. Fortunately, I don't have to make that determination. I think the good name of the President is going to be protected by the facts and by the President himself, and that I won't have to be a party to any circumstances that relate to that.
And it is your testimony that those who have preceded you suggesting that the President had prior knowledge or involved in these activities are totally false?
It is my testimony as I am.
Staff.
Senator,
in these articles, names were named.
Senator, the investigative arm of the federal government, as I think you described it, the FBI, has been investigating this case from June of 1972, and I'm sure their investigation has continued all the way through.
Do you think they did a good job?
I'm not privy to what they did or didn't do. I've heard statements made with respect to the number of investigations, the man-hours, and so forth. I don't know what they did or didn't do.
You've indicated that Mr. Magruder was low on the totem pole, was from the lower echelon. And the fact that he was deputy director of the campaign and had authority to spend unlimited funds, didn't that make him very important?
Senator, we're changing courses here now. I'm just talking about his governmental position the last time. With respect to his activities in the campaign, obviously, he was quite important.
And this is absolutely my last question. I believe that all of us would maintain that we are men of honesty, men of truth, and men of integrity. You've indicated that you have great faith in the President and that his administration is of utmost importance. To what extent would you go to protect the good name of the President?
Senator, I think I answered that same question in another form previously. Fortunately, I don't have to make that determination. I think the good name of the President is going to be protected by the facts and by the President himself, and that I won't have to be a party to any circumstances that relate to that.
And it is your testimony that those who have preceded you suggesting that the President had prior knowledge or involved in these activities are totally false?
It is my testimony, as I answered similar questions yesterday on a number of occasions, that I have no reason personally to believe through anything that I've ever heard or said or seen done that the President had prior knowledge with respect to these matters. And I have a very strong feeling from my discussions with the President over the period of time, and this is a feeling, of course, obviously it has to be, because I don't know what he knows or what others may have told him, but I have a very strong feeling that he does not, or did not, I should say, have prior knowledge with respect to the matter of the break-in or what has become generally referred to as the cover-up.
This is your feeling, sir?
It is my feeling, but I would point out that so far as my personal dealings with the President during this period of time, my discussions with him, nothing has ever occurred which would give me any such indication.
I thank you very much, sir. Thank you, Mr. Chairman.
It appears that John Mitchell is sticking tightly to his reasons for not informing the President. In a moment, it'll be Senator Baker's turn to test Mr. Mitchell's memory and motives. Public television's coverage of the Senate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
As we go back to the hearings, it is the Vice Chairman's turn to probe how Watergate facts were kept from President Nixon.
Senator Baker. Thank you, Mr. Chairman. Mr. Mitchell, your testimony has been significant in many respects. It has given us new insight into important new material. It has also created apparent conflicts with the testimony of other witnesses. I refer particularly, of course, to the testimony of Mr. Magruder and in some instances to the testimony of Mr. Dean, in some minor respects to the testimony of Mr. Stans and others. You know and I know that the function of the law in the evidence-taking or testimony-taking situation is to try to reconcile apparent conflicts, if that's possible, before concluding that any witness has sworn falsely, let alone trying to establish where the truth lies if reconciliation is impossible. I intend to proceed on the assumption that I've proceeded with every other witness that what you have sworn is the truth, and to assume that until the contrary is made to appear, if it is made to appear. And on the basis and the assumption that what you have told us is the truth, I'd like to put certain questions that I believe are material and relevant to this inquiry and important. Would you tell me, Mr. Mitchell, what is your perception of the institution of the presidency?
Is that part of the purpose of this committee, to ascertain from me the perception of the presidency?
I think it is, Mr. Mitchell, because I think your perception, or the perception of anyone who worked with and for the president, of the institution itself has some bearing on the decision-making processes that are undertaken. I think it has some bearing, for instance, on the question of why you did not tell the president of these facts. I know you have indicated that you have answered those questions a number of times before, but I'd like to approach it from the other standpoint. That is, what is your perception of the presidency? And modified still further, what is your perception of your responsibility to the presidency, both as the Attorney General of the United States, as a friend of the president, as a private citizen? What is your perception of the obligations of the presidency and your obligation to it?
Well, Senator, I could, of course, go on for hours as to the perception that I have of the presidency and what it stands for, but I think our Constitution and statutes outline that very clearly. As the chief executive officer of this country, I think that perhaps what you would like to get to is my thought of my responsibility to the presidency.
That's right. I'd like to know your perception of the presidency. I'm rather fully aware of the constitutional description of the office, of the separation of powers, of the derivative doctrines of executive privilege, of the stated constitutional requirements of the president, the obligations of the presidency, and the statutory mandates that are given to that occupant from time to time. But what I'm interested in is your perception of that institution.
Well, of the presidency?
Of the institution.
Of the presidency?
Of the institution of the presidency. Let me give you a few examples to see if it'll help any. Is the president...
Senator, I could go on for days.
Well, I'm forbearing and willing, as a matter of fact, and we may have to do it that way. But it's important enough, at least from my standpoint, to have insight not only into your perception of the institution and your relationship to it, but also of your insight into what may have been the president's perception of that office. Now, let me give you an example or so. Is the presidency so shrouded in mystique? Is there such an aura of magnificence about the presidency? Is there such an awesome responsibility for a multitude of problems and undertakings of this nation that the presidency, in some instances, must be spared the detail,
must be spared the difficulty of situations which in more ordinary circumstances might be considered by some at least to be frank, open declarations of criminal offense. Is the presidency to be protected in that way? Is the splendor of the isolation so great that the president must be protected? And if so, in what cases?
Well, Senator, we can talk to the specifics of this particular case. The presidency and my concept of it and the way I've watched it function is that obviously the president cannot deal with all of the mundane problems that go on from day to day. He has to deal with the greater problems in the area. Now, to get to the point where I come in, and that is, it is my opinion and my concern with respect to this particular presidency that he should not have been involved in connection with these matters that bore directly upon his election, and he should have been protected from the knowledge of them.
Why?
In the interest of his reelection.
Why isn't that a presidential grade decision? Why, of all decisions that might be made by the man, the candidate for President of the United States, why shouldn't he be permitted to make that decision? What is it that arrogates that authority to someone else other than the president to take a material step that will significantly affect not only his election prospects and chances, but his presidency if he is reelected?
Because of the consequences that would obviously flow from it.
Why shouldn't he make that decision?
If he were to make the decision, there would be no alternatives. He would have a choice of being involved in what you all referred to as a cover-up, or he would be involved in the disclosures which would affect his reelection.
Mr. Mitchell, does that or not imply a distrust of the decision-making ability of the man who occupied the office at the time? That is, that you spare him the responsibility to make such a fantastically important decision?
Quite the contrary, and I don't refer to it as a fantastically important decision, and of course in retrospect it has been, and perhaps maybe the best thing would have been to do that.
Wouldn't the best thing to have done?
And it's not a question of distrust of the president.
Then
it's
why
a question of a recognition that if he were advised of the situation, that he would take these actions, which would be deleterious to his campaign.
Then what is your perception of the presidency that leads you to believe that he ought to be spared the difficulty of making a monumental decision?
The very simple point, Senator, that it was an election year in which, if the facts were known to the president, that his course would have been obvious and it would have impeded his potential for re-election. Now, I'm not saying today any more than I said yesterday that this was the right decision. I'm telling you the basis upon which the decision was made.
I understand that. I have a full appreciation of the explanation you've given for why you made the decision, but I'm trying to probe into your perception of the presidency, your relationship to it, your knowledge of the man that led you to make a decision for him.
I think I've put that very simply in the last few sentences that I've stated.
I don't think I quite understand, at least.
Well, let me review it again. Knowing the current president, knowing his respect for the presidency, that there would be no options, no decision-making on his part, he would have unloaded, as I think I said yesterday, on all of the White House horror stories. And this, in my opinion, would have impeded and had a direct effect, an adverse effect on his reelection.
Is there any other important decision that you can think of that the president ought to be spared from making? Give me another example of another situation where the Attorney General of the United States or the chairman of the committee to re-elect the president or an administrative staff or anyone else should decide in order to spare him the lack of options as you've described. What else besides that would come to mind?
In what category?
In any category.
One that he should be spared or one he should be advised?
No, one that he should be spared. Now, for the moment, I'm going to pursue your theorem that this matter had the effect of limiting the president's options if you told him about it, Therefore, you didn't in order to preserve
eliminate
his
his
options.
options. It wouldn't limit them. It
All
would
right.
eliminate
Tell
them.
me another situation that would be similar. Another one that you would not tell the President about. Another consequential decision that you would not tell him about in order to avoid eliminating his option.
Well, I think as your hearings go on here, you will find others in connection with the staging of demonstrations up here in the Capitol and some of the other activities that were undertaken by some of the people who were involved in this campaign, that obviously he would have to condemn if they were known to him.
Isn't what you're telling us, Mr. Mitchell, that in certain cases, in order to preserve a range of political options, that the President should be denied access to the information on which to make a legal and valid judgment as to the propriety of those actions? And if you say yes to that, isn't it true that that theorem has a significant diminishing effect on the powers of the presidency as described in the Constitution? Don't you, in fact, by that arrogate unto yourself a presidential decision?
Senator, I think the answer is yes in all of those particular areas, because obviously the basis of information has to be with the President before he can make his judgments on the subject matter.
What is the constitutional basis for arrogating unto yourself or anyone else a constitutional level, a presidential level decision?
I haven't found one in the Constitution, Senator.
Then what authority is there?
What authority? This is a matter of judgment that you make in connection with these areas.
There are many judgments, some of them legal and some of them illegal. But what basis in
And
law?
some of them, in hindsight, are quite improper, obviously.
How do we protect against the necessity of viewing the world in hindsight?
In doing what to the world?
In looking at the world in hindsight, how do we go about the business of legislating against such occurrences in the future? How do we go about making sure that presidential level decisions, decisions of tremendous importance, are in fact made by the President and not by someone else?
Well, Senator, this happens every day in this Capitol where the President doesn't have information about a particular subject matter.
Well, surely it doesn't happen every day with respect to an illegal entry into the Democratic National Committee or efforts by principal White House staff allegedly to cover up those activities or suborning of perjury or conspiracy. Surely those don't happen every day.
No, but there are many, many circumstances that probably have a greater effect on this country that happen every day within the departments that the President is not aware of, so that he doesn't have the facility to make the decisions that are...
Then your answer to me implies, and I'm not prepared to agree with it, but it implies a defect in the institution of the presidency. That is, the institution itself is not capable of dealing with first magnitude questions. And I really am not prepared to believe that.
I'm not prepared to believe it or agree with it either. I'm telling you that the presidency is perfectly capable of dealing with them if he has the information.
If someone else takes on themselves the decision-making authority in important issues and spares him, is that what you say?
This is frequently done, as you know, and not in particular circumstances that you've just described, but it's done from day to day throughout the government and always has been.
Let's talk about the man for the moment. The President of the United States is a man that you've known for a long time and known intimately, and that I've known for a long time, less intimately, but for a long time. What is there in your perception of the man that would contribute, if it did contribute, to your decision not to tell him about this? I'm not speaking now of the institution, but rather of the man.
I've described that circumstance and answered that question, Senator, a number of times here in the last 2 days, and I'll answer it again the same way. I know the man very well, just as you do, and as I say, he would have lowered the boom on the whole category of the White House horrors, and that this would have then, of course, spread across the whole White House, and, of course, the derivative effect would have been upon the President and would have affected his election.
I'm rather inclined to think you're right. I think he would have done that.
I agree.
But I rather think that your hindsight is remarkable. That you at that time, when you yourself, according to your testimony, were completely free from any involvement in the so-called White House horrors, in the break-in incident on June 17, 1972, and certainly free of any allegations in connection with the cover-up, the payoff, and the like. At that point in time, in mid-June 1972, you made a decision not to tell the President because you were afraid he would fire those involved, even if you don't think of it from any circumstance except how it affects you.
Senator, I'm quite well aware of that.
Well,
I'm well aware of that, but it's not just a question of firing somebody. It's the question of the unraveling of some of these activities that existed over there.
How could you promote the unraveling? How could you promote the ventilation of these circumstances, the exposure to the light of justice of these matters by not telling it?
That's a contradiction, Senator.
No, it isn't.
You couldn't promote him without telling him, because once you told him, you and I have agreed that he would take the action that would unravel them.
You start from the premise it was better not to unravel them, and I start from the premise that it would have been better to unravel them.
Well,
now, is that the basis? Is that the perception that led you to decide not to tell the President the facts?
Exactly. At that period of time, that was a decision that was made. In hindsight, it might have been entirely incorrect. But
Well,
it was a decision that was made.
Wasn't it, Mr. Mitchell? Aren't you dead sure in your mind that that was a mistake, not telling the President?
Senator, I'm not certain that that's the case, because we were talking about the weeks of June in 1972, where I still believe that the most important thing to this country was the re-election of Richard Nixon. And I was not about to countenance anything that would stand in the way of that re-election.
Anything at all?
Well, we can get to some points where I'm sure that...
Where?
I'm sure if it had to involve treason and other high crimes and misdemeanors that were directly related to the office, that there would be a very definite breaking point.
Wouldn't it have been infinitely better, and aren't you certain of this, Mr. Mitchell, in hindsight? Wouldn't it have been infinitely better to line up everybody on the South Lawn of the White House and have the President find out on June 17th, 1972, what in the world happened?
Well, now, are you talking about what, Senator?
I'm talking about the break-in into the Democratic National Committee headquarters at the Watergate complex at 2 o'clock in the morning on June 17th, 1972.
That was not the concern, Senator, and I hope that I've made it clear to this committee that it was not the break-in on the Watergate that was the concern. It was what we've referred to as the White House horror stories.
You're talking about the Houston papers?
No, I'm talking about the Ellsberg matter, the DM papers, the Dita Beard matter, the stories of surreptitious, unauthorized wiretapping and the bombing of the Brookings Institute, et cetera, et cetera, et cetera.
Then let's move forward to June 22nd, when you received your briefing from those involved on what happened at the Watergate.
That's right.
At that moment, in retrospect, aren't you certain now that the country would have been better served and the President would have been better served by calling to account every single person in the administration who even allegedly had anything to do with it, and to express to the President personally what happened?
Now you're talking about not only the Watergate, but these other activities that we just got through.
I'm speaking of everything that occurred from January 20th, 1969 until June 22nd, 1972.
Senator, if I could have been assured at that time that the President had been reelected, I'd agree with you wholeheartedly.
You understand, I'm sure, what an enormous premium then you put on success. And I suppose all politicians put a great premium on success. But do you care to weigh that any further and tell me that the concealment from the President of facts such as you've described as the Watergate horrors, the break-in...
Excuse me, the White House.
The White House horrors and the break-in into the Watergate on June 17th, that all of those things were inferior in importance to the ultimate re-election of the President?
I have no doubt about it at that time, and I have no doubt about it now.
What would the President have to have done before his re-election was not as important as the event? Or what would someone have had to have done, other than the President?
Well, Senator, I'm sure you're well aware that the President was not knowledgeable of it or involved in it. And this would have been a derivative rub-off on him of something that was would have been absolutely unfair and unjustified.
Isn't it unfair that he's now undergoing the hostility and the suspicion of a nation in this respect, with the allegations of cover-up, with the lingering suspicion about what he knew?
Well,
isn't that far more unfair?
That's a statement that I'm not prepared to accept, Senator. I do not believe the nation feels that way, and I don't believe that anybody has come to the point where they have one shred of evidence that he was knowledgeable of the break-in or the cover-up.
I think you and I are talking about two different things. I'm talking about suspicion.
Obviously, because we generally get along fine.
Well, we still do get along fine, and I'm delighted that I have this opportunity to probe into a great mentality of a great man. And I think one thing that I might say in that respect that may shed some light on the situation is a remark you made in Gatlinburg, Tennessee, when you spoke to the Tennessee Bar Association at my request, and you graciously accepted that invitation. And I introduced you at the reception to some of my friends who are attorneys in Tennessee, and I said, Mr. Mitchell, as you know, was once President Nixon's law partner. And our distinguished witness says, no, Mr. Nixon was my law partner. Now, Mr. Mitchell, I have no quarrel with you. I welcome this opportunity to find out where the threshold is, where the crossover point is on the importance of an event versus the responsibility to tell the President. Now, what I spoke of a moment ago was not evidence of the President's involvement. I've imposed on myself a discipline that I will not comment on the importance, the relevance, or the competence of the testimony of any witness until all of the testimony is taken. And I'm not going to do that with respect to the President either. But what I'm talking about is suspicion. And what I ask you is whether or not the decision to expose all of this to the President for a presidential decision wouldn't have been infinitely better than to undergo the suspicion, the blemish, the uncertainty in the minds of the American people that does exist. Not proof. I think the American people are remarkably forbearing in this respect. But the suspicion, wouldn't it have been infinitely better to do that in June of 1972?
In the Monday morning quarterback field and what's developed into the circumstances that exist today, I don't doubt for a moment that you're probably absolutely correct, and I believe so.
The responsibility of this committee is not to fix blame. We have no defendants. We're not trying to establish the guilt or innocence of anyone. We're trying to prevent this in the future by legislative relief. So that statement by you is most helpful. That is, in hindsight, you are certain, are you not, that it would have been better to permit a president to make a presidential-grade decision in June of 1972?
I don't think there's any question about that. Based upon what has developed out of this, Senator, now how it's developed to the point we are today is another question that has to be examined.
Entirely different, separate and aside, and it has to do with guilt and innocence, it has to do with circumstances, it has to do with involvement or non-involvement. But for our purposes as a senatorial committee, our future is to find the ways to avoid this in the future. I mean, our responsibility is to find ways to avoid it in the future, and that's why I keep pressing for your hindsight, whether or not you aren't convinced, and I'm happy you are convinced.
Well, there's no question about the developments that have taken place since the weeks of June of 1972 to July of 1973. I don't think there's any question about it at all.
And Mr. Mitchell,
that it might even have been better, Senator, as you say, take them out on the White House lawn. It would have been simpler to shot them all, and that would have been less of a problem that's developed in the meantime.
It might have been.
Yes, I agree.
Mr. Mitchell, on another subject, and I thank you for your reply in that respect. Replies in that respect, for fear you think I'm advocating the commission of a felony.
Well, Senator, I'm delighted that you at least joined in the delightful thought, regardless of whether or not you countenance it.
I thank you for that. On another matter, this committee has the hope of providing to the Senate of the United States and to the people of the United States what I've referred to as a definitive statement on Watergate. That is, we aspire to have every fact and detail and every circumstance that is humanly possible to develop, and to bring order and coherence to it, and to write a report that will stand as an important document in the political history of the nation. That isn't meant to sound vain. That is obviously the challenge that the Senate placed before us when they created this committee. One of the things that we are delighted for is that, I gather partly on account of your advice and other circumstances, we are not now confronted with the inability to gain the testimony of present or past White House officials and cabinet officers. The doctrine of executive privilege has not been invoked. It very possibly could have been invoked. But we've greatly enlarged the access of this committee to important information because the doctrine of executive privilege and attorney-client privilege have not been invoked. We have another problem, however, and that is to know something of the President's perception of the unique facts and circumstances that only he and one or two others may know about. And in that respect, as you know, we have a letter from the President to the committee indicating that he will not appear before the committee, and I think he has the constitutional authority not to appear before the committee. But I was taken by a statement you made yesterday morning on page 3268 of the record, when Mr. Dash asked you, actually, when did the President make the decision to ask you to direct this campaign in the 1972 campaign? Mr. Mitchell, I do not know as I can answer that question, Mr. Dash. I think the President would have to answer it. Now, if I could invite your attention to two or three matters, I'd like to ask you to advise us on how we can have access to that information without doing violence to the fundamental doctrines of separation of powers, of executive privilege, of the institution of the presidency, or anything else. I refer to the conversation in September that Mr. Dean spoke of, in which he, the President, and Mr. Haldeman were present, and from which Mr. Dean inferred, and he very candidly says he is not certain, but he inferred that the President knew of the cover-up. Now, we know we can have Mr. Haldeman's testimony, as we shall. But what comment can you give me on how we can complete the record in that respect, how we might gain access as a distinguished lawyer and a former Attorney General and a confidant of the President? How can we gain access to the full content of that conversation and the perception of all of the people? It's not significant, I hope, that at that point the lights went out.
As Senator Baker indicated, the problem is in the electrical system of the Senate office building, not in your television. In a moment, the senators will continue questioning John Mitchell, and we will stay with him, even in the dark, through this and in a few moments a second temporary blackout.
I remember when I was a teenager that my father used to come in and turn down the thermostat to run off my friend, so maybe someone's turned out the lights to stop that answer, but would you try to proceed, please, sir?
I'm sure, Mr. Vice Chairman, that you're as well aware as I am as to the difficulty of recollection of what happens at meetings, regardless of their importance or significance, which have happened months and sometimes years back. I would believe and hope that after your hearings are over, that I think the President will respond to the salient points of the hearings of this committee, and I'm sure that that meeting will probably be one of them. Now, I'm not advising the President on the subject matter. I'm not discussing it with him, but I would have a very strong feeling, knowing the President as I do, that he will respond to that subject matter.
Do you think he should?
I believe that he will.
Well, that's not quite what I asked you. Do you think he should?
I believe that he will, Senator. I'm not making this.
I'm not sure it'd help to ask again, so I won't.
No,
Mr. Mitchell,
three strikes and you're out.
No, I'm not out. I'm tired. But if I were to ask you one other question in that respect, if I were to say that I know of no way that this committee could or should try to compel the President to appear and give testimony. I think the most fundamental tenet of the doctrine of separation of powers probably prohibits that. But if I assume that to be true, and I believe it to be true, and if I still continue to have the desire to complete this record, this definitive statement on Watergate, with the President's perception and knowledge, particularly of specific events such as I've alluded to, I've finally come to the conclusion that a statement by the President, while welcome, would not be complete. And I've been groping for some way to try to circumnavigate the rocks and shoals of separation of powers, and executive privilege. And my staff brought to my attention a precedent established in 1919 when the Senate Foreign Relations Committee asked President Woodrow Wilson to appear in connection with the ratification of the Treaty of Versailles. And President Wilson, as I recall, did not even decline to appear. Rather, instead, he invited the Foreign Relations Committee to the White House. And they went. And they had a conversation with President Wilson in rather good detail that was made a part of the official record of that committee and published as a committee document. Now, that in 1919, at least, appeared to solve the executive privilege separation of powers problem for President Wilson and for the Senate Foreign Relations Committee. Can you, or would you care to comment on that as a possible alternative or suggest any other alternative for gaining this information and preserving the precedents that the President has referred to?
Well, Senator, I hope that you all are invited down to the White House, hopefully under the circumstances that you desire.
With safe conduct.
With safe conduct. Well, I understand you do have your protective forces up here that can get you in and out all right. I do hope that somewhere along the line that you will be there under the appropriate circumstances, but it would be brash on my part to make a suggestion as to how the President should handle this question of separation of powers.
Well, it's no more brash for you to say it, probably less brash than it is for me to say it. But I genuinely do value your advice in that respect, and I'd like to have any suggestions you have. But do any other thoughts or ideas come to mind on how we can gain access to this information and perception of the President and still try to avoid an institutional confrontation between the Congress and the President on these doctrines?
Yes, Senator. There's one that very much comes to my mind, that you and the Chairman can go down and discuss it with them. And I'm sure that you may find some mutual grounds upon which to resolve this problem.
Thank you, Mr. Chairman.
Senator Montoya.
Mr. Mitchell, you've had a long-lasting friendship with the President, have you not?
Well, it's not long. I hope it is lasting.
I believe you stated that you met the President the first time in 1966. Is that about correct?
Well, I had met the President before that, but it was in the area of 1966 when I got to see more of him and spent more time with him.
And at that time you had your own law firm, and he was associated with another law firm in New York?
That's correct, Senator.
And what kind of association did you start out with him in New York while he was a member of one law firm and you were a member of another?
Well, it basically had to do with legal matters where the two firms were mutually involved in, and which led to social occasions and lunches and discussions and things of that matter.
How often would you say you socialized with him between the time that you first knew him as a partner in this law firm and the time that the two law firms merged and you became closer to each other?
The question is socializing?
Yes.
Oh, I would say it was relatively infrequent.
But did you get to know him on a very personal basis?
Well, Well, Senator, I believe that the best answer I can give you in connection with that is that I got to know him as an individual. We've had wide-ranging discussions of many subject matters, and of course, as our firms were merged and we practiced law together, the knowledge of the individual and our contacts, of course, increased.
When were your firms merged?
Officially as of January 1, 1967, if I recall correctly.
And did your contacts with the then private citizen Nixon continue and on a more frequent basis?
Yes, sir. As a matter of fact, our offices adjoined each other so that we saw each other quite frequently and spent more time together.
Did you and your family socialize with each other frequently?
Yes, from time to time, yes. I wouldn't say frequently, but from time to time.
And then, subsequent to the merger of the firms, I believe you became his campaign manager in 1968.
Subsequent to the merger of the firms.
Yes.
Sir.
And what was your association with the president during that campaign? Did you see him frequently? Did you visit with him frequently? Did you accompany him in the campaign?
Senator, I saw him when he was in New York. He, of course, was out on the campaign trail. I did not accompany him very often. I did infrequently. But basically, I stayed behind and ran the store.
Well, how would you characterize your association with the president at that time and in the subsequent years? Would you say that you were a very close friend of his, that you were a social friend of his, that you'd been a business partner in a most satisfactory manner with him, and that later you became his confidant and counselor as Attorney General of the United States? Would you say that all these characterizations are correct?
I would put it on the basis that we got along pretty well, yes, sir.
Yes. Now, let us go into Mr. Dean a little bit. Now, Mr. Dean was very complimentary of you in his testimony and gave you great credit for starting him out in the Department of Justice, or at least developing with him a father-son relationship. Now, what do you think of Mr. Dean?
Well, Senator John Dean had been a very, very competent lawyer working in the office of the Deputy Attorney General in the Justice Department and dealing with congressional relationships. There's no question about it. When he went to the White House, of course, my relationship with him was on an entirely different basis, and it got to be less frequent. I think that Mr. Dean is a perfectly competent lawyer.
Was he working under you when he worked in congressional relations at the Department of Justice?
Well, since I was the Attorney General, theoretically everybody worked under...
I mean directly under you.
Not directly under me. He was working directly under, in the organizational chart, the Deputy Attorney General.
And what kind of service did he render in that capacity?
Well, Mr. Dean, as the legislative liaison representative of the Justice Department, carried on just the same functions that we're talking about, that he was a liaison with the Congress in connection with our legislation and our congressional hearings and all of those other matters. Mr. Dean took on one other function that was, as he testified, and that's my recollection, that was delegated to him by Mr. Kleindienst, and that was to negotiate with the demonstrators concerning their permits in the Washington area here.
Now, during the time that he performed services for the Department of Justice, would you say that Mr. Dean followed orders very strictly or very obediently and carried them out as his superiors would want him to carry them out?
Well, of course, Senator, he was working directly under the deputy, but to my knowledge, I have not heard of any occasion when he did not carry out orders. I can't be more specific than that.
Then he went to the White House, and of course you observed him as he worked out of the White House and worked as liaison between the White House and the CRP, the Committee to Re-elect the President. You observed him for many months, did you not?
Yes, sir. I would not say that he was the liaison between the White House and the committee, but he started out performing substantial legal functions in connection with the origin and initiation of the committee, and certainly I saw Mr. Dean from time to time during that time, and of course I saw more of them as we got into the civil litigation and other problems after June 17th.
Well, would you say that he was the type of a man that would act similarly at the White House as he did in the Department of Justice, carrying out orders as he was given those orders?
Well, I would presume that if he had done so at the Department of Justice, that he would continue to do so in his capacity at the White House.
Now, going to the creation of, or going back to the Internal Security Division of the Department of Justice, there's been testimony adduced here, Mr. Mitchell, by several witnesses that the reports of the Internal Security Division were made available to the Committee to Re-elect the President. Are you aware that those reports were made available?
I was aware, Senator, that there was intelligence being made available to the Committee for the Re-election of the President, the Republican National Committee, and I had always assumed the Democrats, and my knowledge of the subject matter is limited to the area in which the decision was considered and made with respect as to whether the convention should be held in San Diego or transferred to Miami. And it seems to me that we were getting intelligence from all over the government with respect to the potential for the demonstrators and the potential for riots and physical violence at the particular area.
What about other intelligence reports on, say, individuals? Be they potential threats at the convention or not, or outside of that sphere?
I do not recall, Senator, and I doubt that they existed, that there was ever an intelligence report that came out of government that had to do with any individual as far as politics or his political position is concerned.
Did you give
At least I was not aware of any.
Did you give any specific instructions that these reports should be made available to the Committee to Re-elect the President?
Now, are you talking about reports out of some part of the Internal Security Division of Justice?
Right.
No, sir. I, of course, had left the Justice Department by the 1st of March, and so to my knowledge, there was no even discussion of such activities until after that.
Well, in other words, the reports were made available to the Committee to Re-elect the President in the limited fashion, as you have indicated, after you left the Department of Agriculture, of Justice?
That is my understanding of it, yes.
Did you ever find out who the source of authority was for this transmission of reports?
No, sir, I never made such inquiry, and as I've said before, I presume that it related entirely to the potential of violence and that it was probably going to both parties. I do recall that, and I think it happened when I was at the Department of Justice, that the Law Enforcement Assistance Administration, for instance, had provided assistance to the police establishment in Miami for both the Democrats and the Republicans in connection with the holding of their convention, and I'm sure they had many meetings on the subject matter.
Did you ever authorize the transmission or even inspection of FBI reports in the Department of Justice?
Authorize their transmission and inspection by whom, sir?
The transmission of FBI reports to the CRP or the inspection of FBI reports at the Department of Justice?
No, sir.
Do you know of anyone who did?
No, sir, I do not.
Do you know whether or not these reports were received at the Committee to Re-elect the President?
I have no knowledge of any such receipt of...
There has been testimony to that effect heretofore.
Senator, are we, to make perfectly clear, we're talking about FBI reports?
Yes.
Yes. Well, then my answers that I've given you stand. I was not aware that anybody testified that FBI reports were being received by the Committee for the Re-election of the President.
Now, let us go back to the meetings that you had at the Department of Justice with respect to the Liddy plan on January the 27th. To put the matter in proper focus, it's my understanding that you met Mr. Liddy on or about November of 1971 when Mr. Dean brought him to you and introduced him to you. Is that correct?
Yes, sir, November 24th.
And then subsequent to this, to wit, on January the 27th, you, Mr. Liddy, Mr. Magruder, and Mr. Dean met in your Department of Justice office where the original Liddy intelligence operation unfolded in charts?
That is correct, sir.
Now, how long did you spend at this meeting?
The meeting, according to the recollection that I have, which comes mainly from my log, was an hour or less, and there was another subject matter discussed, which of course was the upcoming election law.
Now, what was specifically discussed? Will you please relate the dialogue that occurred there in the discussion of the Liddy intelligence gathering plan?
Well, Senator, I couldn't possibly relate a dialogue that took place that long ago, but I can tell you that the format of it was that Mr. Liddy unfolded his program, and everybody just sat with their mouths open and while he discussed it, and then it was terminated, and that was the basis of it. There wasn't any dialogue with respect to the discussion of it other than to shut it off and tell him to go burn it.
And then was there any discussion or statement made, was there any discussion there or any statement made to the effect that he should go back and scale the plan down because the $1 million budget that it encompassed was excessive?
No, Senator, the discussion, as I recall it, was to the effect that that's not what the individuals that were participating in that meeting, certainly Mr. Dean and myself, had in mind. What we had in mind was going back to information gathering and taking care of security against demonstrators rather than the contents of that particular proposal.
All right. What kind of information gathering did you have in mind?
The gathering of all types of information that would be available to the campaign, beneficial to it, that would be done, of course, within appropriate means. That's the way it's always been done in political campaigns.
Did this include getting information from the other side, if you could get it?
There's no question about it.
All right. Now, let's go to the February the 4th meeting. The same subjects came back to your office. Is that correct?
You mean the same individuals
Yes.
came back? Yes, sir.
Mr. Liddy and Mr. Dean and Mr. Magruder came back.
Yes, sir.
And what transpired then with respect to the so-called Liddy plan?
Well, with respect to the so-called Liddy plan, and this was a much shorter meeting, I think of some 20 minutes at the most, with the so-called Liddy plan, when it was discussed, it was turned off again because it had the same concept of electronic surveillance and the other facets that were involved.
Now, tell us how he explained that plan at that meeting.
Well, I'm not sure that my recollection is that good, Senator. The basis of it was that they would have the capacity for electronic surveillance with respect to whatever targets were to be used in connection with the subject matter.
Was it a reduced plan?
It was, oh yes, very much so. You'd cut off all of the horror aspects of it, and it had been reduced down basically to the electronic surveillance.
Mm-hmm. So by this time, you knew Mr. Liddy very well as to what he could do.
Well, I knew Mr. Liddy as to what he was proposing that might be done.
Well, didn't he
I
impress...
couldn't say that I would know Mr. Liddy very well upon these 3 meetings.
Well, didn't he impress you in unveiling this plan, this plan twice, scaling it down? Didn't he impress you as a man who really knew how to gather intelligence?
He impressed me as an individual that had some ideas about gathering intelligence that didn't fit in with mine.
Now, then, on March the 30th, strike that, it is my understanding that at the second unveiling on February the 4th, that Mr. Magruder and Mr. Dean and you all disapproved his plan. Is that correct?
Yes, sir. Most assuredly is.
And there is testimony in the record to that effect on the part of Mr. Dean, on the part of Mr. Magruder. There was no question about the plans on both occasions being disapproved, and they agreeing with you, Mr. Mitchell.
Yes, sir, that's correct.
Now, then you went to Key Biscayne on your vacation after you left the Department of Justice. And while you were there on March 30th, you had a meeting at the home where you were staying, and present at that meeting in Key Biscayne was Mr. LaRue and Mr. Magruder. That is correct, isn't it?
Yes, sir. For the particular meeting you're talking about, Mr. Harry Fleming was down on the previous day also at a meeting that we had down there.
And during the course of that meeting, Mr. Magruder had brought in, as your deputy at the CRP, some decision papers which required your approval or your passing on them. That is correct, isn't it?
Well, let me put it this way, Senator. At that time, I had not officially been associated with the Committee for the Re-election of the President. Undoubtedly, he had decision papers that he wanted to discuss with me, and as I understand them, as I recall, there were quite a few of them.
Well, I understand from his testimony that he brought about 20 different papers which required decision by you.
I wouldn't doubt that there were 20 different papers of different subject matters because I was being brought up to speed on what was happening in the campaign. And as I say, that with respect to whether or not they were decisions by me or whether discussions and consultation approval, I was not officially at the committee at that time. But I'm sure that the papers were brought for the purpose of discussing them with me and getting my reaction to them.
And you did have some meetings with respect to policy at the committee with Mr. Magruder and with Mr. LaRue.
Yes, sir.
Right now, one of these papers was a sheet 8.5 by 10 dealing with the third version of the Liddy plan and scaled down to $250,000. Is that correct?
That is substantially correct, Senator. That's correct.
And what was your decision with respect to this? Now, before I ask that question, strike that question. Now, I understand from testimony heretofore adduced that there were 3 copies of this particular plan. One was retained by Mr. Magruder, and the other 2 copies were used in the deliberations at Key Biscayne. Would you say that is correct?
I have no recollection of it. I recall there being 1 copy there, Senator.
Did you make any notations on any of these papers?
I don't recall whether I've made any notations on any of the particular papers. I can assure you that I made no notations on what you're referring to as the third Liddy plan.
Now, did you approve the Liddy plan?
At the Key Biscayne?
Yes.
I have never approved the Liddy plan as we're discussing it at any time, and certainly I didn't approve it at Key Biscayne.
Correct, isn't it?
Yes, sir. For the particular meeting you're talking about, Mr. Harry Fleming was down on the previous day also at a meeting that we had down there.
And during the course of that meeting, Mr. Magruder had brought in, as your deputy at the CRP, some decision papers which required your approval or your passing on them. That is correct, isn't it?
Well, let me put it this way, Senator. At that time, I had not officially been associated with the Committee for the Re-election of the President. Undoubtedly, he had decision papers that he wanted to discuss with me, and as I understand them, as I recall, there were quite a few of them.
Well, I understand from his testimony that he brought about 20 different papers which required decision by you.
I wouldn't doubt that there were 20 different papers of different subject matters because I was being brought up to speed on what was happening in the campaign. And as I say, that with respect to whether or not they were decisions by me or whether discussions and consultation and approval, I was not officially at the committee at that time. But I'm sure that the papers were brought for the purpose of discussing them with me and getting my reaction to them.
And you did have some meetings with respect to policy at the committee with Mr. Magruder and with Mr. LaRue.
Yes, sir.
Right now, one of these papers was a sheet 8.5 by 10 dealing with the third version of the Liddy plan and scaled down to $250,000. Is that correct?
That is substantially correct, Senator. That's correct.
And what was your decision with respect to this? Now, before I ask that question, strike that question. Now, I understand from testimony heretofore adduced that there were 3 copies of this particular plan. One was retained by Mr. Magruder, and the other 2 copies were used in the deliberations at Key Biscayne. Would you say that is correct?
I have no recollection of it. I recall there being 1 copy there, Senator.
Did you make any notations on any of these papers?
I don't recall whether I've made any notations on any of the particular papers. I can assure you that I made no notations on what you're referring to as the third Liddy plan.
Now, did you approve the Liddy plan?
At the Key Biscayne?
Yes.
I have never approved the Liddy plan as we're discussing it at any time, and certainly I didn't approve it at Key Biscayne.
Did you approve any budgetary request of $250,000?
No, sir, that was part and parcel of the same item that was presented at that particular time, and there was no approval of any part of that subject matter at that time.
Is your recollection very definite on that, or are you saying this because you do not remember exactly what transpired?
No, I have a very, very strong recollection of it, Senator. To think that this same concept would come back again the third time after the decisions and the way the decisions were made in connection with the first 2, there's no question in my mind, and my recollection on this subject matter is very strong.
Then, according to testimony adduced here, Mr. Magruder was supposed to have called Mr. Reasoner in Washington, asking Mr. Reasoner to call Mr. Liddy that the plan had been approved, and to have Liddy call Mr. Magruder back. Are you aware of any of those conversations?
No, sir, I am not, except insofar as they've been testified to before this committee.
Well, you do agree that there is testimony on the part of Mr. Reasoner and Mr. Magruder that that occurred, those conversations occurred.
I'm aware of the testimony that was given with respect to it.
And are you also aware that Mr. Liddy in turn informed Mr. McCord that the plan had been approved on or about that time?
I'm not that familiar with I presume it came out of Mr. McCord's testimony, and I'm not that familiar with him.
Well, the reason I mention this background, Mr. Mitchell, is because here we have three individuals who have offered testimony here, namely Mr. Magruder, Mr. Reasoner, and Mr. McCord, confirming that the plan had been approved. This is contra to what you are stating before this committee. And that is why I asked you whether your recollection might have been a little hazy about this approval.
No, I have no trouble whatsoever with respect to this subject matter, Senator.
So in effect you're saying that they are wrong and you are right.
What I'm saying is that I did not approve that plan on March 30th, if that was the date, at that meeting at Key Biscayne or at any other subsequent time.
All right. Now let us go now to the implementation of that plan. When you now became the director of the CRP, during your incumbency as director, you had periodic meetings with respect to the budget, at which meetings you had the Finance Committee, you had Mr. Magruder, you had Mr. LaRue, and yourself approving the expenditures for the conduct of the particular campaign. That is correct, isn't it?
Yes, Senator, but the Budget Committee also, of course, had Mr. Stans and Mr. Sloan and Mr. Nunn on it, and Mr. Malik eventually became part of that budget group.
I believe Mr. Stans testified that he would go in there as the chairman of the Finance Committee and attend these budget hearings, but actually that the policy for expenditures was set out by your division and your direction. Was that about right?
Well, the meetings really revolved around, in the last analysis, is how much money Mr. Stans could raise, and then we would make determinations as to how much would be spent in what particular area. But of course Mr. Stans also had his input, would object to the fact that you didn't need XDX dollars for television, and direct mail would overlap it, et cetera, but the actual purposes for which the money were expended within the general categories were contained, of course, in the budget.
And who prepared that budget? Was that prepared under your direction? Was it approved before it was submitted or discussed before the Finance Committee?
No, the budget evolved out of the budget meetings, Budget Committee meetings.
Mm-hmm. All right, now, I believe your testimony has been that you did not approve any specific disbursement with respect to any cash that was given to Mr. Liddy in the implementation of the so-called Liddy surveillance or intelligence gathering plan.
That is correct, and I think that is also Mr. Stans' testimony
Now,
relating to the same conversation.
Yes, Mr. Stans so testified that he did not discuss any specific figures with you.
Correct.
That's correct. Now, isn't it odd, Mr. Mitchell, that $250,000 went out of that treasury and you did not know what it went for when the word around there was between Mr. Magruder, between Mr. Stans, and Mr. Sloan, that this cash was being disbursed to Mr. Liddy?
Well, Senator, I don't know what the $250,000 figure comes from or where it comes from, but I believe that there was an expenditure by Mr. Liddy before I arrived on the scene, as testified to by Mr. Stans, of some $125,000. And as I recall, Mr. Sloan's testimony with respect to the total that was turned over to Liddy was $199,000. So we're talking about the difference between $125,000 and $199,000.
Well, then, when you arrived on the scene, you were told about this figure of $125,000. Were you also told what that figure and that expenditure represented?
I was not told of the $125,000, Senator. As a matter of fact, as I testified yesterday, when the post-Watergate investigation came along, it was very, very difficult to get the information out of the individuals involved, and we had the colloquy between Sloan and Magruder. Magruder saying it was $40,000 that had been given to Liddy, and Sloan saying no, it was much, much more, and we had to finally resolve the question with getting Mr. Stans. So if I couldn't get the information post-Watergate without getting it from Mr. Stans, I sure in hell didn't get it voluntarily when I came aboard in April.
Well, what did you mean when you stated that you were aware of the $125,000 figure having already been expended?
I was aware that in what context are you putting this?
With respect to the disbursements to Mr. Liddy.
I was aware of the fact that there was a information gathering, intelligence gathering operation that Mr. Liddy was carrying on. The $125,000, the first time I ever saw it was when Mr. Stans testified here for this committee.
Well, give me the specifics of the intelligence gathering that Mr. Liddy was gathering at that time when you were so informed.
At the time that I was informed?
Yes.
Well, I will have to start back, Senator, to the time when Dean brought Liddy over to the office in November 24th to talk about the position where he was going to get intelligence. This would be part of his activity to get information related, which might be useful in the campaign. There's been testimony here, and I vividly recall the fact that Liddy went to San Diego and did a survey of the then gathering storm with respect to the elements that were going to congregate in San Diego to oppose the holding of a peaceful convention. There was the Democrat National Committee kickback story that was investigated by Liddy at a later date. A number of such items, none of which were of great consequence to me, except possibly the San Diego Convention site problem.
Were you aware that Mr. Hunt was working with him?
No, I had never heard that Mr. Hunt was working with him until after the 17th of June.
Now, Mr. Sloan has indicated here, and so has Mr. Magruder, that you knew and had given authority for the disbursement of this money to Mr. Liddy. Now, their testimony is contra to what you have stated here today. There we have another instance of two witnesses who have testified here who indicate contrary to what you have testified here today.
Senator, I'm not cognizant of what Mr. Sloan has testified to in this area.
Now, I'm just bringing this into proper focus. I'm not trying to dispute the rectitude of what you are saying. I'm just bringing this into proper focus for the record.
Thank you.
Now, then we go into the June 17th date when you were in California. I believe on that date there were quite a few of you engaged in some kind of political activity in California, and you were staying at the Beverly Hills Hotel. Is that correct?
I believe it was the Beverly Hills Hotel. There were a group of us out there, and I think we were all staying at the same hotel.
And on the morning, you were advised as to what had happened here in Washington.
It was, I believe it was morning or noontime out there, Senator, yes.
And you immediately convoked a conference after having breakfast, which you met with the different individuals to try to prepare a reaction report to the so-called bugging at the Watergate, or break-in at the Watergate.
Well, Senator, it wasn't at breakfast, and it was at a place other than the hotel we were staying at. I believe they call it the Airport Marina or something to that effect, where the political activities were taking place. I was to have a press conference after 2 or 3 meetings and a luncheon and so forth, and the convocations, as you call them, were held for the purpose of trying to tell me what had happened and to what response I could possibly have at a press conference in connection with the faxes that then existed.
Who did you receive the information from preliminary to making the press statement there in Los Angeles?
Well, I would believe by that time that Mr. Mardian and Mr. Magruder would have talked to people back in Washington. I'm not certain if there was anybody else, whether Mr. LaRue did or not, but I would believe that Mr. Mardian and Mr. Magruder would have talked to them, and possibly also Mr. Clifford Miller. I'm not certain.
Who did they call here in Washington, and why did they call at the time?
I'm not certain that I can answer either part of that question. Senator, they obviously were calling back to get information, and of course, as it's since been testified, they were called the Public Information Office of the Committee for the Re-election of the President, and I gather other people.
I believe this is the statement which you made in Los Angeles, and I'll quote from it. In a statement issued in Los Angeles, this is from the Washington Post, June 19th, and I quote, "In a statement issued in Los Angeles, Mitchell said McCord and the other 4 men arrested at Democratic headquarters Saturday were not operating either in our behalf or with our consent in the alleged bugging attempt." Referring, and this is a continuation of the quotation, referring to the alleged attempt to bug the opposition's headquarters, Mitchell said, quote, "There is no place in our campaign or in the electoral process for this type of activity, and we will not permit it nor condone it." Now, is that an accurate statement?
It's a very accurate statement, Senator.
Mm-hmm. Now, what did you do in order not to condone it?
What did I do in order not to condone it?
Did you try, after you got back to Washington, to find out who the individuals that might be responsible for this were?
Yes, it did, Senator. As I discussed yesterday, we took and discussed it on the way back on the plane. Mr. Mardian, Mr. LaRue, Mr. Mardian was put in charge of the investigation, and we brought lawyers into the picture as soon as it became evident that we were going to have a civil litigation, and asked them also to investigate it and to interrogate the parties involved.
Well, did you bring lawyers into the picture to represent those who were involved, or to try to extract information, sufficient information from them so that you could be able to pin culpability on those who were responsible?
They were brought in for both purposes.
And what culpability did you uncover as a result of this legal representation?
Well, obviously we uncovered the culpability of Mr. Liddy, at least so far as his refusal to talk to the Federal Bureau of Investigation. And from then on, the question got to be quite hazy as to where the culpability ran from there.
All right. What did you do after you determined the culpability of Mr. Liddy? Did you talk to any prosecuting attorney or any law officer and inform him of Mr. Liddy's complicity in this affair?
I don't believe, Senator, that I'm sure I didn't. I don't know what the people who were conducting the investigation did.
Then, on September 2nd, 1972, the Washington Post, and I quote the Washington Post as follows: Mitchell, following his 20-minute appearance in the office of Edward Bennett Williams, the Democrats' attorney, told reporters outside that he was in no way involved in the Watergate incident, although the questioning under oath didn't get to the point of the Watergate break-in. Said the former Attorney General, quote, "I can swear now that I had no advance knowledge." That is still your testimony, isn't it, Mr. Mitchell?
Yes, sir, that is my testimony.
All right. And then on September 6, 1972, the Washington Post story is as follows. Mitchell told reporters yesterday that the Watergate incident was a ridiculous caper that the news media had blown all out of proportion. Do you still agree with that statement?
Yes, sir, I do.
Do you think that the Watergate incident was a ridiculous caper?
I want to make sure that we're talking about the same thing, and I'm talking about the breaking and entering into the Democratic National Committee. I think it was perfectly ridiculous that it was done. It served no purpose. It was in nobody's interest. And, of course, it should never have happened, and it shouldn't be condoned under any circumstances.
Well, do you believe that the news media has blown this affair all out of proportion?
Yes, I do. In connection with the single act of the break-in and entering, I still believe it's been blown out of proportion. Now, when you get to the total story that's now become known as Watergate, is referred to as Watergate, I think that's an entirely different subject matter than the subject matter that I was talking to in September of 1972.
Well, aren't those just ramifications from the trunk of that tree?
No, I think it goes far beyond that, Senator.
All right. Now, on April the 21st, 1973, another story in the Washington Post, and I quote, "The former Attorney General, who also served as campaign director for Nixon, reportedly told the grand jury that he knew that Magruder would not have moved ahead independently with plans for the bugging unless he had received permission from higher authorities." Would you still say that?
I didn't say it then in those terms, Senator. I think my comments on that particular occasion was that I didn't know who might have been the final authority with respect to it. There was conjecture as to whether or not Mr. Magruder would have moved ahead on his own.
Well, knowing Mr. Magruder as you did, and having heard what the Washington Post attributed to you, what is your testimony today?
With respect to what, Senator?
Would you say that Mr. Magruder, as I have stated, in quoting you, would you say that Magruder would not have moved ahead independently with plans for the bugging unless he had received permission from higher authorities?
My testimony today is the same as it is yesterday. To this day, I do not know as to who was the final authority or who in concert moved this program into its activity.
No, but with respect to Mr. Magruder, do you stick by that statement that he was the kind of a man that would not move except with permission from some higher authority?
Now, you're talking about something the Washington Post said.
Yes.
I think yesterday I found out that I shouldn't always rely on the Washington Post through Senator Talmadge's questioning.
Well, would you...
With respect to that story that you've just read, I say that it was my recollection that I did not specifically make that statement. It was made in the context of I did not know where the final push or shove or approval came from. Now, with respect to your specific question on Mr. Magruder, I do not know whether he, in concert or with others, may have moved ahead on it. I would feel that Mr. Magruder would not have done so unless there was compulsion coming from some other area.
Do you have any speculation as to where that compulsion might have come from?
I tried to answer that question yesterday, Senator, and I believe that the record that's been made by Mr. Magruder and certainly Mr. Dean's testimony has better insight on it than I have at this time.
Well, then, would you say that Dean's testimony is correct in the assumptions that he made with respect to this particular subject?
Now, whose testimony was?
Mr. Dean's.
Well, Mr. Dean, as I recall, his testimony covered a great many areas of hearsay about what people had told him with respect to this subject matter.
Now, then, after Watergate, you appeared at your apartment on June the 19th, and you had a meeting there with some of the people. Now, present at that meeting was Mr. Mardian, Mr. LaRue, Mr. Dean, Mr. Magruder, and yourself. You recall that meeting, do you not?
Yes, sir, I do.
And did you request at that meeting of Mr. Dean to check and see if the White House embarrassment could be prevented?
No, sir. To the best of my recollection, that was not discussed at that meeting. As a matter of fact, as of that time frame of the 19th of June, I was unfamiliar with the White House horror stories.
Did you, at this particular meeting, discuss anything with respect to the gemstone file?
To the best of my recollection, there was no discussion of that subject matter whatsoever.
Well, are you saying that to the best of, are you saying this in light of your recollection and not as a positive statement?
Well, I'm saying, Senator, that there was no discussion of the gemstone file because I hadn't heard of it at that particular time. There was no discussion of wiretap logs or matters of those subjects that took place, certainly not in my presence there.
Well, did you discuss any particular file at that meeting?
To my recollection, we did not discuss anything except to get a briefing from the people who were in Washington, Marty and LaRue and Mitchell just having come back from the West Coast, as to what the current circumstances were and as to how it would be handled with respect to the responses that were actually required to the charges that the Democrats were making out of their committee.
Now, am I correct in saying that before Mr. Dean got there and these other people, that they had already talked to Mr. Liddy about the particular involvement of the CRP?
I think the record will show that Mr. Dean had talked to Mr. Liddy on that day, the 19th, and I think his testimony will also show that he did not discuss any of his activities or any of his meetings on the 19th at that meeting at the apartment that night.
Now, on June 22nd, you had another meeting. Is that correct? Not at your apartment, but somewhere else.
I'm sure I had quite a number of meetings on June 22nd, Senator. I'll take and check my log here, and we'll get to the one that you're talking about.
Well, there's a question here, and it arose from your testimony yesterday that you were not sure whether the subsequent meeting was on the 21st or 22nd. And I'm referring to that particular meeting.
Well, now, which meeting of the 22nd are you talking about, Senator?
Did you have a meeting at the White House on the 22nd?
I had a meeting at the White House every morning at 8:15.
Did you discuss anything relating to the Watergate incident with any individuals at the White House?
To the best of my recollection, the type of meeting that was held at 8:15 every morning, there was certainly no discussion of any of the details of the Watergate matter. It was the staff meeting that was held every morning at the White House under these circumstances, where you had all of the top staff people from Dr. Kissinger all the way through to the congressional liaison people.
And did you, during your subsequent visits to the White House, engage in any conversations with Mr. Ehrlichman or Mr. Haldeman about the course of the investigation as it was being conducted by the lawyers for the CRP and others with respect to Watergate?
Well, I'm sure that somewhere, sometime along the way that these discussions were held, I can't pinpoint any particular meeting. We were more heavily engaged in the matters of the campaign than we were discussing the particular aspects of the Watergate investigation.
Did you discuss the testimony before the grand jury on the part of Mr. Magruder, or the testimony that was going to be presented by Mr. Dean with anyone at the White House?
The testimony that was going to be presented by Mr. Dean?
Yes, before the prosecutors. And the testimony that was going to be presented by Mr. Magruder before the grand jury?
No, to the best of my recollection, Senator, those discussions were not held with anybody at the White House. They were held with Mr. Dean and the lawyers and other people at the committee, and not the White House.
Can you tell this committee whether or not Mr. Haldeman, Mr. Ehrlichman knew anything about the so-called activities trying to cover up the White House involvement with respect to the Watergate?
Well, the White House involvement in what respect, Senator?
Well,
White House involvement in connection with the Watergate?
Yes.
Well, I don't know as there's been any testimony to the effect that the people in the White House were involved in the Watergate.
Well, with respect to the cover-up, then?
Well, eventually, along the road, there was discussions in connection with the fact that there was no volunteering or coming forward, and that there was a design not to have the stories come out that had to do with the White House horror activities. There's no question about that.
Now, let us go into what you stated a few minutes ago, that you were clearly motivated by a sincere desire to see the president reelected, and that's why you failed to tell him all you knew about Watergate at that time. Now, that is a correct statement, isn't it?
Yes, sir, if you will add to Watergate the other activities that we've been talking about.
Well, I believe you stated on cross-examination a few minutes ago by Mr. Inouye, or Senator Inouye, that your sole concern was that the White House horrors should not be disclosed, and that's why you did not tell the president about this situation. Is that correct?
That's correct, Senator.
Now, did it ever occur to you that you could separate Watergate from the White House horrors?
I assume that you're not going to be through with your interrogation right soon, and I believe we got a vote, so we'll take a recess now to 2 o'clock.
The senators are now going to eat lunch, and we're going to pause briefly. In a moment, Senator Montoya will wind up his examination, and then it will be Senator Ervin's turn. Public television's coverage of the Watergate hearings will continue after this pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPACT continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Jim Lehrer.
As the committee is gavelled back to order, it will be the senator from New Mexico asking the questions.
The committee will come to order.
Ready, Mr. Chairman?
Yes.
Mr. Mitchell, just briefly, I think it's been established here that you reviewed the Liddy plan 3 different times. 2 in Washington when you were at the Department of Justice and once at Key Biscayne. That is correct.
I would differ with the word review, Senator. I would put it on the basis that it was presented to me.
All right.
One occasion, of course, was less detail than the other, and of course on the third occasion practically no discussion of it.
Then later on, when after June 17th, it was divulged that some people at the CRP might have been involved in the break-in. You made a statement saying that the CRP was in no way involved and I had no advanced knowledge. Now, did you mean to say that you had no specific knowledge, or did you mean to say that you were not aware of the Liddy plan at that time?
No, Senator, that was entirely related to the event of the break-in at the Democratic National Committee.
All right, now, after the June 17th affair, you had several meetings with the President, and you indicated that you did not want to divulge to the President what you had ascertained. Now, for the reason that you did not want to impair his chances of re-election. Now, after the election, did you think about this? And did you think of the advisability of advising the President after the election? Because no longer was your motivation in order at the time.
Yes, sir. As I previously testified, I did consider it. In retrospect, probably should have gone ahead with it at that particular time.
Why didn't you do it?
I'm not certain that I can give you a rationalization for it other than the fact that there was, of course, the fond hope that there would be changes in the White House personnel and that the individuals certainly were not going to pursue the type of activities that they had in the past, and that the President wouldn't be burdened with the knowledge that these things had taken place in his White House.
Well, on October 5th, 1972, the President made this statement, made it to the American people, and I quote from the presidential documents, and I quote, "I wanted every lead carried out to the end because I wanted to be sure that no member of the White House staff and no man or woman in a position of major responsibility in the Committee for Re-election had anything to do with this kind of reprehensible activity." I presume you read that statement. I presume you were aware of it. Didn't this trigger in your mind the possibility that you might reverse your determination not to tell the President before the election?
Did you say that was October 5th?
October the 5th, 1972.
Well, that, of course, was before the election, and I don't recall any particular thoughts that I had on the subject matter at that time, Senator.
Well, you were fully aware that the President was making public statements indicating that he was trying to get to the bottom of all this, were you not?
Yes, sir, I was aware of that. And I'm sure that he was using the proper departments of government to do so. And in spite of this, you did not come forward and tell him what you knew about Watergate? That is correct, Senator. And your concern being that you did not want to trigger off any action that might impair the President's re-election, and that's why you did not advise him before the election. Didn't it occur to you that your desire to insulate the President against disclosure by you of the exact details of Watergate was not exclusive, because there were others close to the President who might have done the same thing? I'm sure there were others that were close to the President that might have had the same thoughts and the same opportunities. Well, I don't know what their subjectives are. Well, what I mean is that the possibility existed at that time that if you did not tell the President that Mr. Ehrlichman, Mr. Haldeman, or Mr. Dean might do this, did you insure against that thing happening? No, sir. We had no discussions along the lines that you are inferring with respect to the subject matter. Well, if your interest was so profound in trying to trigger off any presidential action that might endanger his chances of re-election, why did you not go to people close to the President to make sure that they would not tell the President about the details involving Watergate? I believe that they are capable of making their decisions on their own. I obviously made mine, and I presume that they made theirs independently.
All right. Now, we have the situation here before this committee, and I'll close with this, Mr. Mitchell. We have the situation of whether or not the Liddy plan was approved. Was any part of the plan approved by you?
No, sir, none whatsoever.
Did you disapprove of the Liddy plan at Key Biscayne?
Yes, sir, I did.
Completely. Did you disapprove it all 3 times?
Yes, sir.
All right. That's all, Mr. Chairman.
Mr. Mitchell, on yesterday, when Senator Talmadge asked you concerning your political activities in respect to the committee to re-elect the president, while you were still serving as Attorney General, you pointed out that it was not illegal for you to do that.
Yes, sir, that is correct,
Yes.
Mr. Chairman.
Now, I think we might meditate just a minute on what St. Paul said. He said, all things are lawful unto me, but some things are not expedient. Don't you think it's rather inexpedient for the chief law enforcement officer of the United States to be engaging in directly and indirectly in managing political activities?
I do, Senator.
Yes. I was in hopes that that was what you were going to do, because when you appeared before the Judiciary Committee on your nomination back on January the 14th of 1969, you and I had this little colloquy.
I remember it very well, Senator.
Senator Irvin, Mr. Mitchell, until comparatively recent years, it has been customary for presidents to appoint the Postmaster General his chief political advisor and agitator. Unfortunately, during recent years, this role has been largely taken away from the Postmaster General and given to and exercised by the Attorney General. To my mind, there is something incompatible with marrying the function of the chief political advisor and chief agitator with that of prosecutor of crimes against the government. Now, I would just like to know whether you think that the primary function and objective of the Attorney General should be giving political advice or doing political agitating before congressional committees or enforcing federal law and acting as an advisor to the President and his cabinet in legal matters rather than political. Mr. Mitchell, Senator, I would hope that my activities of a political nature have ended with the campaign. I might say that this was my first entry into political campaign, and I trust it will be my last. From the termination of the campaign and henceforth, my duties and functions will be related to the Justice Department and as a legal and not the political advisor of the President. Senator Irvin, thank you, sir. I commend your answer. And I'm very sorry that you didn't carry out the purpose you announced on that occasion.
Mr. Chairman, that would have been my fondest wish. Unfortunately, it is very, very difficult to turn down a request by the President of the United States.
Now, don't you think that what we've been investigating here indicates the desirability of the Congress giving serious consideration to divorcing the Department of Justice from political matters?
I would perhaps even go further and suggest that you divorce all of the departments from political matters. I think it would be a very constructive move.
Now, here we had a criminal prosecution in which the prosecutors held office at the pleasure of the President. And the tracks from the burglary in the Watergate led directly into the committee to re-elect the President. And it turns out that the lawyers who were defending the seven men indicted in the criminal action were paid either directly or indirectly, by the committee to re-elect the president or presidential aides in the White House. And that's a condition which is not calculated to accomplish justice, in my opinion. Of course, you were out of the Department of Justice at that time. Now, twice while you were still Attorney General of the United States and the Chief Law Enforcement Officer of the United States and the Chief Legal Advisor to the President of the United States, meetings were held in your office in the Department of Justice in which such matters were discussed as proposals to bug the opposition political party and to burglarize the headquarters of the opposition party and to employ prostitutes to induce members of the opposition party to disclose secrets, weren't they?
They were so discussed and, of course, disapproved.
But the burglary and the bugging was discussed in the second.
That is correct.
Yes. And then on the third occasion, namely on the 30th of March, Mr. Magruder, who was your deputy director of the committee, went to Key Biscayne where you were and discussed these matters, at least the bugging and the breaking, a third time with you, didn't he?
I wouldn't use the term discuss. They were presented in terms.
And presented to you.
That's correct, sir.
And you say that you declined to approve them.
That's what.
And you declined to do that on the 3 occasions.
That is correct, sir.
Can you inform me as to why it was after you declined on the first occasion that you had a second discussion on the matter? And after you declined on the second occasion that you had a third discussion of the matter or presentation of the matter?
I cannot for the life of me understand as to why this matter was constantly brought back, except for the point that somebody obviously was very interested in the subject matter.
Well, wouldn't the evidence justify the inference that you did not communicate your disapproval in such an emphatic amount, enough manner to prevent the bugging and the breaking?
No, I think the testimony of Mr. Dean and my testimony of yesterday and today is quite to the contrary. In fact, this was not the type of concept that was envisioned.
Well, Mr.
It was
Dean,
quite different.
Mr. Dean was not the man that was in charge of your committee when you were absent, was he?
No, I'm not saying that. I'm making reference to the fact as to the manner in which these items were disapproved.
And the man who was in charge of your committee when you were absent was Mr. Magruder, wasn't he?
That is correct.
And didn't you find out shortly after the 17th day of June that Magruder had financed the burglars?
Yes, sir. That was in the week following the break-in.
In other words, it appeared very shortly that 5 burglars had been caught in the Watergate, and that one of them was Mr. McCord, an employee of your committee.
That's correct, sir.
Yes. And it also appeared that 4 of the burglars at that very time had in their pockets money which came from your committee.
That was eventually established, yes, sir.
Very shortly thereafter, wasn't it?
I believe at the end of the week following
Yes.
the break-in.
I'm informed there's a vote on, so we'll have to go and vote.
This is the first in a series of interruptions as the senators go vote on amendments to a bill that would authorize construction of an oil pipeline through Alaska. Senator Ervin will pick up where he left off.
Now, very shortly, after you found out the things I inquired of you about, you also found that Liddy, who had been general counsel to the committee, to the finance committee to re-elect the president, and another employee of your committee, E. Howard Hunt, had been arrested for complicity in the break-in.
Senator, may I point out that, to the best of my knowledge, Mr. Hunt was never an employee of either one of the committees. Mr. McCord.
Well, Mr. Hunt was employed in the White House, wasn't he?
I have learned that since, yes.
Well, you found out sometime at summer, didn't you, that Mr. Hunt had been sent over to the committee by Mr. Colson?
Yes, sir.
Yes. And you found out about the same time that Mr. Hunt had been implicated in the burglary of the office of the psychiatrist of Ellsberg.
Yes, sir.
And you found out, therefore, that Hunt, a burglar, had been retained on the White House payroll from September 1971 till the break-in.
Well, excuse me, I wasn't aware of the periods, but I did learn that he had been a consultant to the White House.
And then after you came back from California, you talked to Mr. Robert Martin and Mr. Fred LaRue and Mr. Dean and Mr. Magruder about these matters.
That is correct, sir.
And from your conversation with these men, you realize that Dean and Magruder had participated in the break-in, and that he and Dean were engaged in what has been called a cover-up.
If I can answer just slightly different, Mr. Chairman, well, we did learn that Magruder had obviously been providing the funds that were used in connection with the activities of the group that did break in.
And did you not find out that Dean and Magruder were trying to conceal these events?
Well, this came quite a bit later down the pike, but we did obviously learn that this was the case.
About how long afterwards?
I would believe that it would probably be in the middle of July or sometime thereafter.
And you also found that money which had been contributed for the re-election of President Nixon had found its way into the bank account of Barker, one of the burglars in the Watergate.
Yes, sir. That came forward quite early.
And then Magruder told you that, in effect, well, first, you talked to LaRue and Martin, and they both knew about these events. You can tell that from the conversations they had with you, didn't you?
They told me, repeated what Mr. Liddy had told them, yes, sir.
And that was that he had participated in this, had instigated this burglary at the instance of Magruder.
That is the basis of their representation to me as to what Liddy had said.
Yes, and now from that, your conversation with Robert Martin and Fred LaRue, you learned that they had been apprised of that fact.
That's correct.
Yes. You also were informed by Magruder that Magruder was prepared to commit perjury when he went before the grand jury in August rather than to reveal what he knew about these matters.
That was correct, sir.
Yes. Now, did you agree that that was a proper course of action to take?
It was a very expedient one, Senator, and at that time in the campaign so close to the election, we certainly weren't volunteering any information.
Yes. Well, were you advising, did you advise Mr. Magruder that perjury was a felony and he ought not to commit perjury? When he proposed to you that he commit perjury?
I'm sure Mr. Magruder was well aware of it.
Yes. Well, did Mr. Martin and Mr. LaRue ever talk to you about the Magruder's proposal to commit perjury?
They were present when, on an occasion or more, in which Mr. Magruder stated what he was going to testify to.
Now, did you ever have any conversation with Mr. Haldeman about these matters?
Not until much later on, Senator.
Oh, how much later on?
This year.
You mean you never had any conversation with Mr. Haldeman until 1973?
About the subject matter that you're referring to, with respect to...
What about Mr. Ehrlichman?
I've had no such conversations with Mr. Ehrlichman.
Did you have any information at the time of these other White House horrors, as you call them, about Mr. Ehrlichman trying to enlist the aid of the CIA to suppress investigation of the Mexican checks by the FBI?
No, sir, I didn't learn of that until of more recent date here when it's been made public.
You knew about all these other things, however, before the indictments were returned in September against the 7 original offenders.
When you say all of the other things, you mean the items that we have just
Yes.
discussed here? Yes, sir, I did.
Yes. And you were aware of the fact that sometime about early in September or late August, the President made a statement to the American people to the effect that nobody involved, nobody presently employed in the White House had anything to do with any of these matters?
As I recall the statement, Senator, and I'm not sure that I can recall it specifically, I believe the statement was to the effect that there was nobody in the White House was involved in the breaking and entering of Watergate.
In the statement, the President didn't make any, his statement, as you construed it, didn't indicate that the President was saying that nobody in the White House knew anything about it. About to cover up.
Well, I believe the statement referred to involvement. I could be wrong because I don't remember the contents of it, but I believe that was the case.
Well, I think you stated that Mr. Strong was a liaison between Haldeman in the White House and the committee to re-elect the President.
I think you can broaden that, Senator, the fact that he was a liaison between the White House and the committee to re-elect the President.
Yes. And did you not learn that he had been advised about by Mr. Dean and Mr. Magruder as what was going on in the committee to re-elect the President at these times?
Well, Mr. Strawn was constantly being advised as to what was going on in connection with the matters at the Committee for the Re-election of the President. In fact, attended meetings from time to time at the committee.
And he attended that for the purpose of advising the people in the White House as to what the committee was doing, didn't he?
I presume
Yes.
that's his purpose.
That was his sole function, wasn't it?
I don't know what else he did in the White House, but it was the sole function of his relationship with the committee.
Now, as I understand your testimony, you talked to the President twice about Watergate. The first time in June 1972, and the second time on the 22nd of March 1973.
Now, when we talk about Watergate, Senator, those were two occasions upon which they were discussed. I also testified yesterday that in some of the political meetings that were had, the general subject matter was discussed as to how the President should approach it with respect to a type of a Warren Commission or special prosecutors and other such items. These were in large groups.
Well, you had a conversation with the President about Watergate in June 1972, didn't you? I believe it was June the 20th.
It was the 20th of June, a short telephone conversation. That is correct.
And you apologized to the President for Watergate.
I apologize to the President for not keeping track of the personnel in the committee to the extent that the Watergate matter could have happened. Now, this is the 20th of June before I'd learned of a lot of other circumstances.
Well, you had learned enough by the 20th of June to feel that the committee to re-elect the President, or at least some officials of it, were implicated in the Watergate break-in, didn't you?
With respect to McCord, yes. And this is the basis for my apology.
Yes. Well, didn't the President ask you what you meant by your apologizing?
I think I made it quite clear to him that I hadn't exercised sufficient control over the activities of all of the people in the committee.
Well, didn't the President ask you then what you knew about Watergate and why you were apologizing?
I think I told him what I knew about Watergate at that particular time, which was very, very little.
Well, he could have learned about McCord by reading the newspaper, couldn't he?
Obviously.
Indictments were returned in September against the 7 original offenders.
When you say all of the other things, you mean the items that we have just
Yes.
discussed here? Yes, sir, I did.
Yes. And you were aware of the fact that sometime about early in September or late August, the President made a statement to the American people to the effect that nobody involved, nobody presently employed in the White House had anything to do with any of these matters?
As I recall the statement, Senator, and I'm not sure that I can recall it specifically, I believe the statement was to the effect that there was nobody in the White House was involved in the breaking and entering of Watergate.
In the statement, the President didn't make his statement, as you construed it, didn't indicate that the President was saying that nobody in the White House knew anything about it. About to cover up.
Well, I believe the statement referred to involvement. I could be wrong because I don't remember the contents of it, but I believe that was the case.
Well, I think you stated that Mr. Strong was a liaison between Haldeman in the White House and the committee to re-elect the President.
I think you can broaden it, that, Senator, the fact that he was a liaison between the White House and the committee to re-elect the President.
Yes. And did you not learn that he had been advised about by Mr. Dean and Mr. Magruder as what was going on in the committee to re-elect the President at these times?
Well, Mr. Strawn was constantly being advised as to what was going on in connection with the matters at the Committee for the Re-election of the President. In fact, attended meetings from time to time at the committee.
And he attended there for the purpose of advising the people in the White House as to what the committee was doing, didn't he?
I presume
Yes.
that's his purpose.
That was his sole function, wasn't it?
I don't know what else he
Yeah.
did in the White House, but it was the sole function of his relationship with the committee.
Now, as I understand your testimony, you talked to the President twice about Watergate. The first time in June 1972, and the second time on the 22nd of March 1973.
When we talked about Watergate, Senator, those were two occasions upon which they were discussed. I also testified yesterday that in some of the political meetings that were had, the general subject matter was discussed as to how the President should approach it with respect to a type of a Warren Commission or a special prosecutors and other such items. These were in large groups.
Well, you had a conversation with the President about Watergate in June 1972, didn't you? I believe it was June the 20th.
It was the 20th of June, a short telephone conversation. That is correct.
And you apologized to the President for Watergate.
I apologize to the President for not keeping track of the personnel in the committee to the extent that the Watergate matter could have happened. Now, this is the 20th of June before I'd learned of a lot of other circumstances.
Well, you had learned enough by the 20th of June to feel that the committee to re-elect the President, or at least some officials of it, were implicated in the Watergate break-in, didn't you?
With respect to McCord, yes. Yeah. And this is the basis for my apology.
Yes. Well, didn't the President ask you what you meant by your apologizing?
I think I made it quite clear to him that I hadn't exercised sufficient control over the activities of all of the people in the committee.
Well, didn't the President ask you then what you knew about Watergate and why you were apologizing?
I think I told him what I knew about Watergate at that particular time, which was very, very little.
Well, he could have learned about McCord by reading the newspaper, couldn't he?
Obviously, that's
yes.
where I learned about it.
And every day, the newspapers and the other media of communication were, from that time on till the present, were carrying new revelations about Watergate, weren't they?
From time to time, that was a correct statement, yes, sir.
Now, when did you learn that Colson had allegedly sought to persuade Caulfield to bomb the Brookings Institution?
Oh, it was sometime during one of the conversations I'd had with Mr. Dean along the way.
When did you first learn about the operations of Segretti?
When I read about them in the newspapers.
And when was that?
sometime in the fall of 1972.
You hadn't learned about that before September?
No, sir, I had not heard of Mr. Segretti.
When did Secretary Stans tell you that he had furnished $75,000 to assist in paying the counsel fees for the counsel for the 7 Watergate defendants?
Same time he told it to this committee. I saw it on television. That was my first knowledge of it.
You had no knowledge of that before?
No, sir.
Well, did Mr. Dean come to New York and talk to you about the demands of some of the defendants for money?
Yes, he did. Later in the year, I believe the occasion had to be in November, or perhaps even later than that.
Didn't you hear anything about the fact that these defendants were demanding money for counsel fees and for support during the summer of 1972?
I did not, as I've testified here yesterday, Mr. Chairman, the Marty and Liddy discussions, Marty and LaRue discussions with Liddy, the matter was mentioned as to whether or not the committee could provide money for the bail for the individuals, and that was turned off by the committee. Apparently the activities of raising money for support and counsel fees continued on, and it wasn't later until sometime in the late summer or fall that I heard about the activities.
You did hear about, you were given to understand that either the committee or Mr. Kalmbach were furnishing the money to pay counsel fees and support to the families of the 7 Watergate people.
Yes, sir, I heard that, as I say, later on after the time frame.
And later you informed that there was some doubt as to whether McCord would stand fast in silence, weren't you?
I was so advised, yes.
Yes, and you were asked to see what you could do about that, weren't you?
About what, Senator?
To see what McCord was going to do.
I'm not quite sure, Mr. Chairman. I get your thrust of your question.
Well, who told you about the fear that McCord might not remain silent?
I believe it was Mr. Dean.
And when was that?
Sometime after the first of the year, I would believe.
Now, you mentioned the fact that there had been some talk from somebody that came to your notice to the effect that Hunt said he wouldn't take a promise of immunity from anybody except Colson. When was that?
That was sometime directly after the first of the year also, I believe.
Clemency got immunity.
Preceding the trial. Mr. Dean related that conversation, and it had to do with the fact that Mr. Hunt's interest in executive clemency would only be accepted from Mr. Colson.
Now, as I recall, you testified after you'd moved to New York that you came down to Washington, was here on the 22nd of March, and had attended a meeting where the President and Dean and perhaps Ehrlichman and Haldeman were present.
Yes, sir, that's correct.
And you discussed this committee.
Yes, sir.
And the President was adhering at that time to the notion that he could invoke executive privilege and keep any of his present or former White House aides from testifying before the committee. Isn't that so?
I believe that the fact that that impression had been put out from the White House was one of the reasons for the meeting. Obviously, of course, the President could waive it any time he wanted to, and that was one of the subject matters that was discussed at the meeting of March 22nd.
Well, didn't you advise him not to invoke any such claim of executive privilege?
I had told the President, and I presume it was by way of advice if he thought it was appropriate to accept it, and this is, of course, in the time frame of the Gray hearings, where this subject matter became very lively, in which I suggested that I thought that his only problem, his only public problem with respect to these matters was the fact that he was indicating that he would invoke executive privilege with respect to the staff in the White House, and I thought that this was something that he should not do because it was putting him in a very poor light.
Well, don't you agree with me that any person, whether it's a president or a senator or a hod carrier, anybody else, who gives the impression to the public that he's withholding information within his power is putting himself in a bad light?
Did we start off with the senators and then the
I came down
hod carriers?
I started up with the president. I came down by gradations.
Well, Mr. Chairman, if we'll leave out the president, I'll certainly agree with you wholeheartedly. I think the president has a separate question with respect to the separation of powers, and
I was discussing psychology. From a psychological standpoint, don't you think that the president who withholds information or papers about a matter that's being investigated runs the risk of having many Americans draw an inference that the reason he withholds them is because he realizes they'd be unfavorable to him?
I think they may, but I'm sure that there is not always that simple question. There are other factors involved that have to be weighed, and you frequently have two risks that have to be weighed. Certainly, I'm sure it's the case in this area.
Well, do you accept the concept of that executive privilege entitles the president to deny a court or a congressional committee the testimony of his former or present aides about everything?
It depends entirely upon the area,
yes,
Mr. Chairman, and of course if they are conversations or direct communications with the president, and particularly with respect to certain subject matters, I think that he has that power.
Well, let me state my concept of executive privilege and see whether we agree or disagree. I think a president is entitled to have kept secret confidential communications had between him and an aide or had among his aides, which were had for the purpose of assisting the president to perform in a lawful manner one of his constitutional or legal duties.
Senator, I agree with that
yes,
concept.
And I think also that is the full scope and effect of executive privilege. Since the president, there's nothing in the Constitution requiring the president to run for re-election, I don't think that executive privilege covers any political activities whatsoever. They are not official and have no relation to his office. Do you take the position that the president's entitled to keep political secrets from the Congress or political activities on executive privilege?
Not under the outline that you have provided.
I also take the position that the executive privilege does not entitle a president to have kept secret information concerning criminal activities of his aides or anybody else, because there's nothing in the Constitution that authorizes, makes it the official duty of a president to have anything to do with criminal activities.
I would agree.
Yes. So I cannot see if the president has if any aide has any information about criminal activities, or if any papers in the White House that constitute reports to any White House official about criminal activities, that they are privileged in any way whatsoever.
I would have to qualify that with respect to certain areas that might involve national security, and if we'll leave that out, I will agree with you.
Well, national security is defined in the executive order as comprising only two fields. First is the national defense, and the other is our relations with foreign countries. I don't think there's anything else that falls in the field of national security according to the definition in the executive order which was signed by President Nixon. And I think that's also clear. The acts of Congress make it very clear what national defense is.
Well, I quite agree with you.
Yeah.
I've made the exception, and you've very properly, I think, defined it.
Yes, well, I thank you. Now, I want to read you something that you managed President Nixon's campaign in 1968 as well as in 1972, didn't you?
Well, I managed it for a while in 72 and for most of the time in 1968.
Now, in his campaign in 1968, Nixon appealed to voters for their support in these words: America is in trouble today, not because her people have failed, but because her leaders have failed. Let us begin by committing ourselves to the truth, to see it like it is, and to tell it like it is, to find the truth, to speak the truth, and to live the truth. Now, you have any reason to think that between that time and 1972 that President Nixon had changed his position, his fidelity to the truth?
I have no doubt whatsoever that his fidelity to the truth is the same as it was in 68.
And yet he said that the way to save America in 1968 was to find the truth, to speak the truth, and to live the truth. And yet when 1972 came and these White House horrors became known to you, you didn't take the advice that President Nixon gave us all in 1968, did you?
Not under that particular guideline, I assure you.
In other words, not only true in your case, but it was true in the case of Mr. Martin, Mr. LaRue, Mr. Magruder, Mr. Dean, and Mr. Ehrlichman, wasn't it?
Well, I can't characterize those gentlemen and their activities.
Well, didn't any of them, you know that Mr. Dean knew about the Watergate affair to some extent, that Mr. Martin knew about the Watergate affair to some extent, that Mr. LaRue knew about the Watergate affair to some extent, and that Mr. Magruder knew about it to some extent, and that none of them made any public statement disclosing what they knew.
With the use of the words "to some extent," I will agree with your statement, sir.
Now, you've told us that you talked to the President on many occasions, either in person or by phone, between the 17th day of June, 1972, and March the 22nd, 1973. Isn't that right?
There were a considerable number of occasions. Most of them, of course, were in group meetings.
Did the President, did you at any time tell the President anything you knew about the White House horrors?
No, sir, I did not.
Did the President at any time ask you what you knew about Watergate?
Not after that first discussion that we had on the telephone. I believe it was on June 20th.
Well, if the cat hadn't had any more curiosity than that, they'd still be enjoying his 9 lives, all of them.
Well, I hope the President enjoys 8 more.
Another vote. I'll take a little recess.
As the senators go to the Senate floor for another vote on the Alaskan pipeline bill, we'll take a break. Public television's coverage of the Senate Watergate hearings will continue after a pause for station identification.
Unabridged coverage of these hearings is provided as a public service by the member stations of PBS, the Public Broadcasting Service. From Washington, NPAC continues its coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. Here again, correspondent Robert McNeil.
As the senators come back from their latest vote, Senator Ervin wants to know why the president cannot testify before this committee.
Mr. Mitchell, as I understand your testimony, you knew that Magruder was subpoenaed to go before the grand jury sometime about August.
I knew that Magruder made an appearance before the grand jury in August, yes, sir.
And he had told you that he was prepared to commit perjury rather than reveal the truth.
That is correct.
And am I doing you an injustice to ask you whether or not you preferred for Magruder to commit perjury rather than reveal the truth?
I don't think any of your questions, Senator, could possibly be an injustice. The preference, obviously, was that the matter not be disclosed.
Now, you state that you kept silent concerning the things you knew because you considered the re-election of President Nixon of such extreme importance.
That is correct, sir.
Do you know anything about any plans to use the money that had been contributed for the re-election of President Nixon in 1968 or 1972 to sabotage the campaigns of the other Democratic candidates?
I don't know what your word sabotage means, Mr. Chairman. I do know that there were activities that were carried out that I've learned of subsequently. They're all second and third hand information.
Now, I want to talk to you just a little bit about the presidents. I don't consider, you and I may disagree on this, but I don't consider the occupant of the office of president, as important as that office is, to be a sacrosanct person, occupying a position above the law and above all other Americans.
If you wish a response from that,
I'd be glad to have you comment on it.
My comment would be that the presidency obviously has to be held in the highest regard, respect, and obviously he's not above the law, nor is any other citizen.
Well, why should a president be immune from subpoena or from voluntarily appearing before a congressional committee investigating a matter of the importance of this matter?
Senator, I'm out of the business of giving legal advice, at least for the time being, and I don't think that I can comment on that subject matter.
Well, the only thing I've ever seen definitely on that point was the opinion of Chief Justice Marshall in the Aaron Burr case in which he ordered a subpoena, new case taken, to be issued for Thomas Jefferson to come to the circuit court in Richmond and present some letters he'd received from General Wilkinson. And so far as I know, that case has never been overruled or disputed by any court. Now, I wonder if your statement ought not to be changed a little bit. You say that you didn't want President Nixon to find out about the White House horrors. Isn't it the fact that you didn't want the American people to find out about it?
Well, I think that's one and the same, because as I testified before, that if the president had found out about it, obviously he would have pursued his responsibilities in that area very vigorously.
And you were afraid to tell the president, rather you, I won't say afraid, but you preferred not to tell the president and didn't tell the president because you didn't want the president to do what you call lowering the boom.
That's exactly correct.
And if he had lowered the boom, why, the thing would have been exposed.
I don't think there's any doubt about it.
And the American people would have learned about it.
They would have learned about it.
And it might have affected the votes of the American people.
It's quite conceivable.
Yes.
I don't expect to the extent that some of us might believe. I think that's a matter for debate, but it certainly could very well have affected the election.
I have a high opinion of American people in that. I think that the president had lowered the boom. If you'd told the president lowered the boom, and had come out performing his constitutional duty to see that the laws be faithfully, take care that the laws be faithfully executed, I think he would have made his election more sure than ever.
Well, except for one circumstance, Senator, and that is, of course, they impute the wrongdoings of the lowest individual in the White House, of course, right to the top. This is where the problem always seems to arise.
Now, don't you think that there's danger of people doing that if the president persists in his determination not to come before this committee?
I'm not sure that I understand your question.
Well,
Mr.
the president announced about Friday, I think, the day, that he would not appear before this committee and that he would not allow this committee to have access to what he called presidential papers, which seemed to cover all of the papers in the White House and in the executive branch of the government. I don't know exactly what he meant by that.
Well, I'm sure I don't either, Mr. Chairman.
But isn't there a rule of evidence that when a person refuses to produce evidence within his power to produce, that an inference may be drawn that the reason he doesn't produce it is because he knows it would be unfavorable to him?
This, I believe, is the rule of evidence in the courts of law. When you're dealing with the separation of powers involving a president, I think it has to be looked at perhaps in a different light.
But isn't that a rule that applies just as much to search for truth as it does to courts of law? It's a rule of logic, it seems to me.
I would agree with you with respect to the search for truth. There's no question about it. But as I say, there's another factor involved here, and that has to do with the separation of powers.
Well, I don't believe there's anything in the Constitution that says the powers of the presidency should be separated from truth. At least I've never seen it.
I would have thought that the founding fathers that wrote the Constitution might have left that out by design.
Well, I don't think it ever occurred to them that a president wouldn't be willing to do just exactly like President Nixon said we ought to all do, and that is to seek the truth, to find the truth, to speak the truth, and live the truth. I was somewhat intrigued by the question that Senator Montoya asked you. Now, your explanation that you were afraid that the revelation of the White House horrors prior to November the 6th might have some disastrous effect on the election. But when the 7th came, that danger was past. And why didn't you tell the president, knowing that it's one of his chief duties on the Constitution to take care that the laws be faithfully executed on the day after the election, or after the election sometime, about what you knew about this?
Well, I would repeat what I said previously, Senator, that it wasn't my responsibility to do so. There were other people involved. They were changing the guard, so to speak, at the White House, and that the fond hope was that the presidency would not be hurt by the activities of others that were carried on in the White House.
And was it your fond hope at that time that the truth would never overtake anybody other than the 7 people in the original case?
Well, it was my fond hope that whatever came out of it would not mar the presidency.
Well, there was another president named George Washington who had an advisor named Alexander Hamilton. And Alexander Hamilton laid down 2 precepts. One was, but you must by all means avoid the imputation of evading an inquiry and protecting a favorite. Is it conceivable that you're trying to protect the president? Or was it conceivable you're trying to protect the president?
Protect the presidency, not from the fact that he was involved, but the fact of the derivative activities of those of the White House might cast the cloud upon the President.
And Hamilton also stated, it was my duty to state facts to the President. You don't feel like it was your duty to state facts to the President?
Under certain circumstances, there's no question about that.
Well, in respect to the Watergate, the White House horrors, you never felt any compunction either before or after the election to ever advise the President as what you knew?
In retrospect, Mr. Chairman, after the election was over, I probably should have done so. I didn't, and it probably was a mistake.
Well, as a matter of ethics, don't you think you should have advised him about these matters just as soon as you learned about them?
Well, that is a much more difficult question, because as I've said before many times here in the last 2 days, that I had the feeling that it would affect his re-election, and I thought that that was paramount.
Now, did you state that that you never told the President about Watergate, except the matter that you mentioned on the 21st of June, rather, and he never asked you anything about Watergate? You don't know what information the President might have gotten about this matter from other sources, do you?
No, I have no information on that, Mr. Chairman.
Mr. Mitchell, I want to thank you. You've been extremely patient with me, and you've been extremely patient with the committee.
I appreciate that, Mr. Chairman.
Senator White.
Mr. Mitchell, I'm going to repeat a question that was asked of you this morning by Senator Inouye, and I'd like to have an answer to it. Senator Inouye asked you, to what length are you now willing to go to deceive in an effort to avoid further implication of the President in the activities under investigation by this panel? More specifically,
Senator, I can't hear you. I'm sorry.
Senator Inouye's question to you this morning, Mr. Mitchell, was, to what length are you now willing to go to deceive in an effort to avoid further implication of the President in the activities under investigation by this panel? More specifically, are you willing to lie to protect the President? To which question you responded, Senator, there's one great thing about the answer that I can give to that question to you. I do not have to make that choice because, to my knowledge, the President was not knowledgeable, certainly about the Watergate, or certainly knowledgeable about anything that had to do with the cover-up, if that is the phrase that we are using, so I do not have to make that choice. Now, Mr. Mitchell, I'm just going to ask you the same question. I don't consider that an answer to Senator Inouye's question, and so I'll repeat his question and also my question. Would you lie at the present time to protect the President?
Well, I should answer it the same way I did this morning, Senator, but I will add to it that if you were putting a hypothetical question to me, the answer would be no, that I would not, here under oath. And I'm answering a hypothetical question.
Now,
so far as my knowledge is concerned.
On September the 5th, 1972, in the deposition in the case of Lawrence O'Brien versus James McCord, when you were asked the following question by Edwin Bennett Williams, you were asked, Was there any discussion at which you were present or about which you heard when you were campaign director concerning having any form of surveillance on the Democratic National Committee headquarters? Your answer at that time on September 5th, 1972 was, "No, sir, I can't imagine a less productive activity than that." End of quote.
That is correct, and I stand on the answer that I gave this morning that refers to the activities of the security group the question was asked with respect to.
But of course, even by September the 5th, 1972, you had been informed by Mr. LaRue and Mr. Mardian on June the 21st as to what had occurred, had you not?
Yes, but this question, of course, was pre the June 17th event, as I recall the question and the whole line of questions.
The question was asked to you, Mr. Mitchell, on September 5th of 1972.
I'm well aware of the date of it, Senator, but I'm talking about the context in which the question was asked.
And in other words, you feel that you answered that question truthfully?
I did.
On March the 29th, 1973, you made the statement in a CRP press release, "I deeply resent the slanderous and false statements about me concerning the Watergate matter, reported as being based on hearsay and leaked out of the Urban Committee. I have previously denied any prior knowledge of or involvement in the Watergate affair, and again reaffirmed such denials." End of quote.
And I've so testified here in the last 2 days.
And again, this was said on March 29th, 1973, even though you have also testified before this committee of the meetings of January the 27th and February 4th, and then the meeting with Messrs. Mardian and LaRue on the 21st of June, and you still make this statement on March 29th, 1973.
And that statement does not contradict the facts as I have so testified here.
Now, you've testified that on June the 21st, 1972, you were briefed by Messrs. Mardian and LaRue concerning the statement Liddy had given them the day before. Now, why did you fail to mention your knowledge of this information when you were interviewed by the staff of this committee on May 10th of this year? And in fact, you only gave the information to the staff on July the 9th, after it came to your attention that the committee had met with Messrs. LaRue and Mardian and had this information in their camp. Why did you wait, in other words, until July the 9th to indicate your knowledge of a meeting which you had called between yourself, Mardian, and LaRue?
Senator, I did not call that meeting, and I'm not sure it was held on the 21st or the 22nd. Mardian and LaRue came in to brief me on the subject matter, and as I recall my meeting with the staff up here, whatever date it was, I was being responsive to the questions that they were asking me.
Well, you were asked specifically what you knew of the cover-up, and you denied any knowledge except that you had heard that payments were being made to the defendants, which you agreed to in fear of revealing the plumber's activities.
Excuse me, Senator. I was present with Mr. Mitchell on that occasion, and I remember it very well. It was the day that an action had been taken up in New York involving Mr. Mitchell, and the whole interview was very courteous, very brief, and very general, only attended by staff members. And to the very best of my recollection, every question that was asked was answered, and answered truthfully. And it was made very clear at that meeting that they really regretted the circumstances of the timing of the interview, and that we would come back for more detailed and substantial interviews, which we did.
All right. Let's start at the beginning here, if we can, in going over the testimony that has been presented by you, and do some probing. I must confess, Mr. Mitchell, that as I have sat here and listened to your testimony, the only difficulty I find with it is that it is sometimes difficult to realize that we have sitting before the committee not some administrative assistant to some deputy campaign director, but we have the campaign director sitting before this committee. And indeed, we don't have some deputy assistant attorney general sitting before the committee. We have the Attorney General of the United States sitting before the committee. Now, on the 27th of January, 1972, Gordon Liddy presented a plan in your office, in the office of the Attorney General of the United States. And that plan, complete with visual aids, included elaborate charts of electronic surveillance and breaking and entering and prostitution and kidnapping and mugging. Now, you've indicated that in hindsight, you probably should have thrown him out of the office.
Out of the window, I think.
Maybe even out of the window, in hindsight. The life of every American, his, or to a great degree, his liberty, protection of all of his rights sits in the hand of the Attorney General of the United States. And do you mean to tell me that you sat there through that meeting and, in fact, actually had the same man come back into your office for a second meeting without in any way alerting appropriate authorities, in this particular case, the President of the United States?
That is exactly what happened, Senator. And as I say, in hindsight, it was a grievous error.
Grievous error when? That you didn't notify him right away, or that you didn't notify him at all?
I think both. I don't think it would have been necessary to notify the President with respect to the meetings in the Justice Department. I think they should have been handled differently on a little different level.
I mean, after listening to what we would both agree are outlandish plans, that you were neither moved to great anger in your capacity as Attorney General of the United States, which certainly everything that he proposed runs contrary to what you're supposed to stand for at that moment.
I was moved to considerable anger. That's the reason that the plans were turned down, and he was told to go and burn them and forget about such things.
Well, obviously you didn't make much of a point on the man since he was back in your office on February the 4th. Isn't that correct?
He should have understood, got the message.
Yeah, but I mean, he came back into he was there in your office on February the 4th.
Yes, with an entirely different concept. Not the concept that was one that would be improved, but with an entirely different concept.
The economy plan.
I wouldn't put it as an economy plan. I'd put it on the basis that it was considerably changed, but he still hadn't gotten the message as to what the interest of the committee was, or should have been.
The fact is, forget 1 minute politics. Let's just talk about your position as Attorney General of the United States. I find it inconceivable, and unless there seems to be at least some willingness to share a portion of the mentality, that you didn't go ahead and have the fellow arrested for even suggesting this to Attorney General of the United States.
Well, Senator, I doubt if you can get people arrested for suggesting such things. But as I said...
For suggesting illegal acts to the Attorney General of the United States, I think that probably is grounds for arrest.
Do you really, Senator?
I do.
I would have some doubts. I don't know what part of Title 18 would cover that, but that's not the point that I'm sure you're trying to get at. The point is that I think that I made it eminently clear that those acts were not in accord with the concept that we had for the purpose of gathering information and intelligence and to secure the campaign against harmful demonstrators. That was the concept of the plan that was discussed, and as if you recognize Mr. Dean's testimony, it was so stated at one of those meetings that that was the concept in which we were interested.
Well, now, it is true that the elements of the plan contain considerably more than just actions against demonstrators.
Well, there's no question that the plans presented did, but it was not the intention that the activities of Mr. Liddy and the gathering of information intelligence and the protection of the campaign against demonstrators was the concept in which we were looking forward to and which we understood would be the case.
Now, since your sensibilities as Attorney General were not overly offended in this matter, what about your sensibilities as the shortly to be appointed director of the President's campaign effort? Here's a man that is standing before you as the chief counsel of his re-election effort. I mean, it didn't occur to you to call up the President and say, listen, I've got some pinwheel in my office here that is going to be the counsel to your re-election campaign, and I think I ought to warn you. I think I ought to warn you, you've got a lot of trouble on your hands. This didn't even, in other words, in a political sense, it didn't occur to you to go ahead and warn anybody to get this fellow off the boat, if you will?
Senator, it never occurred to me that anybody would carry out such activities, particularly without any authorization to do so.
Did it ever occur to you that anybody would present such a thing, Mr. Mitchell?
It was pretty hard to conceive, but I do not know why it was done or who was the author or the sponsors of it. The fact of the matter is that it was turned down very hard and terminated on that very day in which it was presented.
Well, in any event, he still had sufficient standing before the Attorney General and before the to be director of the campaign so that he was back in your office on February the 4th with, admittedly, a scaled-down plan. But let's get back to the 27th of January, 1972. At 11:15 in the morning, you go through this presentation, which both of us would describe as incredible. At 2:30 that afternoon, you talk to the President of the United States. And no mention is made at all of what had transpired in the office of the Attorney General that morning?
Absolutely, Senator. I don't know how often you get to talk to the President of the United States, but he is the one that normally initiates the conversation and the subject matters that are discussed.
But no conversation. Is incredible. I have never heard, and I'm sure that you had never heard of such a plan in all your career in politics. Certainly I've never heard of such a plan. So this isn't just something that stands just over the line, if you will. I mean, this is fantasy. This is unbelievable. And this man is holding a responsible position in the committee to re-elect the President. You have the opportunity to talk to the President hours after this idiot is in your office, and you say nothing. Is that right?
That is correct.
Now, you stated in your testimony yesterday on page 3280, you have the transcripts there.
No, sir, I don't, but
well, in any way that
we'll be glad to listen to it.
In any way that the committee can be helpful to you, because I don't want to in any way catch you on something. I want you to have the words before you. Stated in your testimony yesterday on page 3280 that Mr. Magruder was wrong when he said you, quote, were focusing on the Democrats and Mr. O'Brien because of Mr. O'Brien's vocal activities in connection with the ITT case. What I'd like to do is to refresh your memory. Specifically, you stated, Mr. Mitchell, it did, but there again, this is in relation to the February the 4th meeting. Mr. Mitchell, it did, but there again, there are faulty recollections with what was discussed at that meeting, what the concept of it was. I violently disagreed with Mr. Magruder's testimony to the point that the Democratic National Committee was discussed as a target for electronic surveillance for the reasons that he gave. Number one, with respect to the Democratic kickback story. We are talking now about the 4th of February. Mr. Dash, Yes, I know. Mr. O'Brien's the reason for centering in on Mr. O'Brien, I believe. Mr. Mitchell, that is correct. And, of course, the newspaper man did not have his column that Magruder referred to until the 23rd of February. He said we were focusing on Democrats and Mr. O'Brien because Mr. O'Brien's vocal activities in connection with the ITT case, and Mr. Anderson did not publish his column until the 29th of February. And so that what I'm pointing out is that this meeting was a relatively short meeting. It was rejected again because of the fact that it had these factors involved. But these targets were not discussed. Now, do you want to stand, Mr. Mitchell, with that statement that this was the first knowledge that you had of the Anderson column when it was published?
That I had the first knowledge that I had of the Anderson column?
In other words, that the implication is that it was not until the Anderson column on February 29th that you became significantly concerned with Mr. O'Brien's effectiveness with the ITT story. In other words, 24 days or 25 days after the February the 4th meeting.
Well, Mr. O'Brien had written a letter that had received practically no publicity whatsoever, and it wasn't until the Anderson column about the Dita Beard memorandum was published on the 29th that this received any publicity or any concern.
In other words, you had received a letter from Mr. O'Brien actually back in December of 1971.
I'm not sure whether I received it or somebody else did, but it had no concern as far as the political picture was involved. The concern arose after the publication of the December 29th column by Mr. Anderson.
But in fact, there was a concern with Dita Beard with the ITT matter as early as February 4th. That your concern was not precipitated by the Anderson column. Is that correct?
I'm not quite sure that I got your double concern, Senator.
Well, let me be very specific. You've already indicated you had received a letter.
What I'm saying is that it became a matter of public controversy at the time that the Jack Anderson column was published on the February 29th, and it was not of great moment before then.
Well, let's examine that for a minute. On February the 4th, 1972, is it fair to say that the ITT matter was a potential concern?
Not so far as I can recall, or not so far as I would assess it under the circumstances of which you've just related.
Well, do you recall that there had been newspaper articles? There had been newspaper articles back in 1971 relative to IT&T, relative to the Dita Beard not the memorandum, but the subject matter of it?
Yes, I recall that ITT matter was constantly in the newspapers, but I'm talking about the circumstances that arose which it received the great notoriety after the publication of the Anderson column.
And it is true that you had received an earlier letter from Mr. O'Brien.
I'm not sure whether I received it or whether the President received it or who received it. I knew that there was such a letter, but there wasn't very much attention paid to it at the particular time, and it certainly didn't receive a great deal of public clamor.
Had Mr. Anderson's office contacted you relative to the Dita Beard memorandum prior to its publication in the press?
I believe that, if my memory is correct, that they called the Public Information Office and the Justice Department the day they were to publish it or the day before.
Specifically on February the 25th.
It could have been that far back, but I would doubt it. That, or at least that's not my recollection. It could be.
And then on February 29th, Dita Beard was spirited off to Denver by Mr. Gordon Liddy. Is that correct?
I don't know what date it was. This was one of the matters that Mr. Mardian and Mr. LaRue told me that Mr. Liddy had told them. But what the dates are, I am not aware of it. and was not aware of it at the time.
You were not involved then. You were not involved with the plans to spirit Dita Beard off to Denver by Mr. Gordon Liddy.
No, I can assure you that that is the case.
Who was in charge of that operation?
I don't know. You will have to ask the parties that were involved in it. The only information I had came through the Marty and LaRue discussion with Mr. Liddy, who stated that he had been involved in it.
Now, Mr. LaRue states that on March the 30th, 1972, when Mr. Magruder presented the Liddy plan to you in Mr. LaRue's presence, but rather than rejecting it, you merely told Mr. Magruder that it did not have to be decided at that time. Is there any way that you can relate to Mr. LaRue's testimony as to what occurred at that moment in time?
No, my recollection is very distinctly as to what I testified on yesterday, that the matter was rejected, and it was rejected on the basis that I was tired of hearing of these things and didn't want to hear about them again.
All right, now let's move to your meeting with Mr. Liddy on June the 15th, 1972, 2 days before the break-in. What time of day did you usually leave the office when you were Attorney General or Campaign Director?
It ranged all the way from 6 to 9.
Well, in the first 5 months of 1972, your logs show no appointments after 6 p.m. Does that seem to correspond with your recollection?
No, after 6 p.m.?
That's right.
Well, I haven't been through them to ascertain that, but it wasn't unusual for me to work on until 7 to 8 o'clock, sometimes 9 o'clock at night.
Well, there's no record of it, certainly that I have in my possession, and the pattern of ending at 6 o'clock or before continues into June with one exception. On the 15th of June, you had a 6:40 p.m. appointment. An appointment with a man whose events turns out to be not to have been seen coming to and from your office, G. Gordon Liddy. Now, this after-hours appointment happened only once in all the time, at least as the logs that we have, that you were Attorney General or Campaign Director in 72 prior to June 17th.
Senator, are you aware of the purpose and the contents of that meeting?
I'm going to get, my question is simply, you maintain that this meeting was not arranged because you were aware you were meeting with a man whose association could embarrass you.
That is not the case at all, Senator. Do you want the facts as to how the meeting was structured?
Yes, I'd like to have the facts as to how the meeting was structured and the content.
It's very simple. Mr. Liddy had written a letter to the Washington Post, which was subsequently published, at the request of Mr. Stans, responding to some charges that were made by somebody on the staff of the General Accounting Office about the failure of the Finance Committee to comply with certain provisions of the Corrupt Practices Act. The letter was brought to Mr. Shumway, who was in charge of public information at the Committee for the Re-election of the President. Mr. Shumway said that he did not want that letter published without my approval. So Mr. Shumway brought Mr. Liddy into my office. We looked at the letter, and I gave the approval to its publication, and that was the total sum of that meeting. And that is the only time that I saw or talked to Mr. Liddy from the 2nd day of February, or 4th day of February.
In other words, there's no particular significance in the fact that this meeting was held after hours. I see nothing in the content of the meeting as to why it couldn't have been held at any other time of day, but on this particular day, this meeting was held after hours totally contrary to the patterns of the
Well,
past.
it's not contrary to the pattern necessarily, Senator. The fact that appointments aren't made after 6 o'clock, although I'm sure there must be some in here, the fact that appointments aren't made after that hour may be because people aren't available, but I certainly was working at the committee and also at the Justice Department for long times after 6 o'clock.
Now let's get to Mr. Dean's role in relationship to you. According to your logs, you did not meet with John Dean for more than a month before the Watergate break-in. Now, do you recall anything? This is as best as I've been able to construct the record. Do you recall anything that would contradict that record?
I don't recall. I haven't checked my logs to that extent, sir.
All right. On June 19, shortly after you returned from California, you met with Mr. Dean and others in your apartment. Is that correct?
That is correct, sir.
According to your logs, you then met with Mr. Dean on June the 20th twice, June the 22nd, June the 23rd, June the 24th. June the 25th was a Sunday, and there are no logs for the 26th, 27th, 28th. But you met again on the 29th and on the 30th. In other words, here's a man that you scheduled no appointments with for over periods as long as a month, and then following June 17th, you met every day, excepting holidays and trips out of town. Now, is that substantially correct, Mr. Mitchell?
I would believe
There's no record of it, certainly that I have in my possession, and the pattern of ending at 6 o'clock or before continues into June with one exception. On the 15th of June, you had a 6:40 p.m. appointment. An appointment with a man whose events turns out to be not to have been seen coming to and from your office, G. Gordon Liddy. Now, this after-hours appointment happened only once in all the time, at least as the logs that we have, that you were Attorney General or Campaign Director in 72 prior to June 17th.
Senator, are you aware of the purpose and the contents of that meeting?
I'm going to get, my question is simply, do you maintain that this meeting was not arranged because you were aware you were meeting with a man whose association could embarrass you?
That is not the case at all, Senator. Do you want the facts as to how the meeting was structured?
Yes, I'd like to have the facts as to how the meeting was structured and the contents.
It's very simple. Mr. Liddy had written a letter to the Washington Post, which was subsequently published, at the request of Mr. Stans, responding to some charges that were made by somebody on the staff of the General Accounting Office about the failure of the Finance Committee to comply with certain provisions of the Corrupt Practices Act. The letter was brought to Mr. Shumway, who was in charge of public information at the Committee for the Re-election of the President. Mr. Shumway said that he did not want that letter published without my approval. So Mr. Shumway brought Mr. Liddy into my office. We looked at the letter, and I gave the approval to its publication, and that was the total sum of that meeting. And that is the only time that I saw or talked to Mr. Liddy from the fourth day of February.
In other words, there's no particular significance in the fact that this meeting was held after hours. I see nothing in the content of the meeting as to why it couldn't have been held at any other time of day, but on this particular day, this meeting was held after hours, totally contrary to the patterns of the past.
Well, it's not contrary to the pattern necessarily, Senator. The fact that appointments aren't made after 6 o'clock, although I'm sure there must be some in here, the fact that appointments aren't made after that hour may be because people aren't available, but I certainly was working at the committee and also at the Justice Department for long times after 6 o'clock.
Now let's get to Mr. Dean's role in relationship to you. According to your logs, you did not meet with John Dean for more than a month before the Watergate break-in. Now, do you recall anything? This is as best as I've been able to construct the record. Do you recall anything that would contradict that record?
I don't recall. I haven't checked my logs to that extent, sir.
All right. On June 19, shortly after you returned from California, you met with Mr. Dean and others in your apartment. Is that correct?
That is correct, sir.
According to your logs, you then met with Mr. Dean on June the 20th twice, June the 22nd, June the 23rd, June the 24th. June the 25th was a Sunday. There are no logs for the 26th, 27th, 28th. But you met again on the 29th and on the 30th. In other words, here's a man that you scheduled no appointments with for over periods as long as a month, and then following June 17th, you met every day, excepting holidays and trips out of town. Now, is that substantially correct, Mr. Mitchell?
I would believe that's the case, and I would believe you'd find that also after the trips out of town and into the fall, there were continued and constant meetings with Mr. Dean, dealing with the civil litigation, with many of the facets that were involved in connection with the problems that the Watergate presented.
Well, let's stay to these meetings right after the 17th of June, starting with June 19th. Was the discussion during the course of these meetings Watergate?
On June 19th?
June 19th?
That was the one at the apartment.
Right.
It most assuredly was the discussion of Watergate, because that was the purpose of the meeting. We had just returned from California, and we were being brought up to date as to what the information was on the subject matter and how we would handle it with respect to a response to the charges that the Democrats were making about it.
All right. Now, you met twice on June the 20th.
I'm sure that the same subject matters were covered.
June the 22nd.
Senator, obviously, I can't tell you what was discussed at each of these meetings, but I'm sure that in connection with most of the meetings that I had with John Dean during this period of time, it dealt with the Watergate.
Well, I'd imagine. I mean, that's fair enough. Then I just wanted to establish the fact that there was no relationship here, certainly not on a regular basis, until after the Watergate, at which time there was a continuing relationship between yourself and Mr. Dean, and you've answered my question that the principal discussions centered around the Watergate. All right? Is that right?
That's correct, sir.
Now, as far as Mr. LaRue is concerned, again, is it not true that you had close contact with him during this particular period of time?
Yes, I had very close contact with him because, of course, he was involved in the political campaign as well as assisting Mr. Mardian in connection with the investigation of what went on in relationship to Watergate.
And Mr. Mardian, he was the one that had been selected.
That's correct.
So that your relationships here, then, are insofar as Watergate are concerned, can we say that they really center around John Dean, Bob Mardian, and Fred LaRue?
Basically, that's the case. And, of course, at a later date, sometime in the second week of April, the lawyers that were retained by the committee in connection with the civil litigation.
All right, then, outside of the litigation aspect of it, Mardian, LaRue, and Dean, is there anybody that you would add to that group as being the group that you were in consultation with relative to Watergate?
I would have to add in the council because they were the ones that were interrogating the people in the committee. They were handling the civil litigation, the depositions that were about to be taken or were being taken in connection with it. And then, of course, you will find meetings there in which some of the people that you've mentioned have added to them Mr. Cliff Miller, Mr. Van Shumway, Mr. Powell Moore, Mr. Richard Moore, in which we were working on the responses to the charges that the Democrats were making from day to day in a public relations point of view.
Now, on June the 19th, Mr. Magruder has testified, and Mr. LaRue has stated that Mr. Mitchell, that you instructed Magruder to destroy the gemstone files, to in fact have a bonfire with them. Now, you deny this having ever occurred. Can you give me any reason why these two men would lie about this fact?
Well, I don't know whether they've lied about it or whether there's a difference of opinion. As you know, Mr. Dean has also testified that there was no such discussion at the meeting. And I would point out, as I say again, that as of that particular time, I didn't have any knowledge that there was such a thing as a gemstone file.
Did you suggest that any documents be destroyed, not necessarily gemstones?
To the best of my recollection.
At the June 19th meeting at your apartment, did you suggest that any documents be destroyed, not necessarily gemstone or not necessarily documents that relate to electronic surveillance?
To the best of my recollection, when I was there was no such discussion of the destruction of any documents. That was not the type of the meeting we were having.
Well, what was the type of meeting that you were having?
Just the one as I've described earlier. It had to do with we being brought up to date, just having gotten off an airplane from California, being advised as to what the current circumstance was and what was to be the response of this committee, the Committee for the Re-election of the President.
Did you instruct at that meeting Mr. Mardian and Mr. LaRue to go and see Mr. Liddy the next day?
No, I don't, to my recollection. I would point out that Mr. Mardian and Mr. LaRue and I had been on airplane for 5 hours that day, and I'm not certain whether I did anything more than ask Mr. Mardian or instruct Mr. Mardian to get on top of this matter, to see what had happened and to find out what and who, if anybody else in the committee, were involved in it, and that is what he undertook.
Well, they did interview Liddy the next day.
I'm not sure whether it was the next day or the day after, but it was in that time frame.
All right, then let's move to June the 20th. And let's go to your calendar. 8:15 a.m., White House meeting. 10:32 a.m., Magruder meetings, LaRue meetings, Mardian meetings.
That's all the same meeting, Senator.
Magruder, LaRue, and Mardian.
That's correct.
1:40, Mardian meetings. 2:05, Magruder meetings, Timmons meetings. 4:15, Stans meeting. 4:50, Magruder meetings, Daly meetings.
That's Pete Daly, who was the head of the media operation.
Right. 5:30, Magruder, Saddam, LaRue, Mardian. Now, at any of these meetings with Magruder, LaRue, Mardian, or with LaRue and Mardian, or with any one of the individuals, did you receive a report on Mr. Liddy's activities?
I tell you, Senator, that I recall having received the report at a meeting with LaRue and Mardian alone, and these meetings do not seem to fit into that circumstance. I think that probably a later period in time, which was probably on Wednesday, the 21st, where I noticed that there is a meeting in which only LaRue and Mardian participated, I believe that that would probably be more likely the meeting in which they described to me of their conversation with Mr. Liddy.
All right, and that meeting, according to your log, probably took place somewhere between 5:30 and 6 o'clock in the evening. Is that correct?
It says in my log it's from 3:20 to 4 o'clock.
On the log of Tuesday, the 20th of June.
No, I'm talking about the 21st of June.
Well, I'm talking about the 20th.
Is there a
I
meeting?
started off this questioning relating to the 20th of June.
Oh, I say on another page here there is a meeting at 6 o'clock that involves Fred LaRue and Bob Martin, so it could have been either one of those days.
Well, in this one, it's on Tuesday, and at the bottom it shows on the log, your log, Magruder, Saddam, LaRue, and Mardian, except within the large parenthesis. Do we have June the 20th up there? Within the large parenthesis that includes all four, Magruder and Saddam have a small parenthesis, as if they had a meeting, and then also Mr. LaRue and Mr. Mardian had a meeting.
Are we still on June 20th?
That's right.
It says in this log, which is a photostatic copy of the original, that on 5:30, at 5:30 I saw Saddam and Magruder, and at 6 o'clock LaRue and Mardian joined the above, so that LaRue and Mardian came into a meeting that was already in existence.
Well, now, what is missing at this point from your log, Mr. Mitchell? Anything? Let's assume what you've just told me to be correct. What is missing from your log?
I haven't the faintest idea what
well,
you're
let me
making
inform you
reference
what's
to,
missing
Senator.
from your log, and you have now indicated to me that at 6 o'clock you have Magruder and Saddam and LaRue and Mardian there with you. And not in your logs, but from the White House logs, is a phone call from the President lasting from 6 o'clock to 6:12.
That might very well be the case.
And that phone conversation, did it relate to the Mardian-LaRue report?
If If it was from the President, it obviously didn't relate to the report. And I say I have a very distinct recollection of having had the discussion with Mardian and LaRue alone, and that's why I believe that it probably took place on the 21st when I did meet with Mardian and LaRue alone, and not on the 20th when there were two other people shown at the meeting.
Well, they could have been there, they couldn't have been there. That's something that you've got to rely on your recollection. The way it's set up here, and I have a photostat of the log, it's possible that LaRue and Mardian were alone. That's something that you have to go ahead and resolve. But in any event, it's a fact that at 6 o'clock you talked to the President that day.
That's what the log so shows.
Does anything come to mind as to what the subject matter was of that conversation?
The best of my recollection was the conversation of the 20th as I have described it here before the committee. It was a relatively short conversation, and it was in this particular conversation that I apologize for the President for not having kept better control over the activities of some of the people that were at the committee for the re-election of the President.
And then you talked to the President from 6 to 6:12, which entry is not in your logs, and at 6:50 you talked to John Dean, and at 7:15 you talked to John Dean.
Now, which day are we talking about? The 20th?
20th? Same day, Mr. Mitchell.
That so shows. Now, if you're trying to ask me what the subject matters of those conversations were, I haven't the faintest idea that I can recall them. I've talked to Mr. Dean, as the log shows, many, many times over the period of the next number of months.
Let me ask you one question. In other words, this series of events, then, that involves LaRue and Mardian, phone call from the President, meeting with Dean, is as you've described it, and in no wise did you transmit any information gained from Mardian and LaRue to either the President or to John Dean.
Senator, I am certain that I did not have that information at the time that I talked to the President on the 20th of June.
How come the President's call is not on your log?
I haven't the faintest idea.
In the meeting with Mardian and LaRue, did they tell you about the Memorial Day break-in at the Democratic National Committee?
Now you're talking about the debriefing.
That's right.
Of Liddy.
That's right.
Yes.
They did tell you.
That's my recollection.
And when was the debriefing of Liddy?
This is what we've been trying to get at.
Well, roughly, can you give me a...
Well, I believe it was sometime on the
20th or 21st?
20th or 21st.
May I read to you a transcript? Case of Lawrence O'Brien versus James McCord et al., dated Tuesday, September the 5th, 1972. Did it ever come to your attention, or were you given any information that members of the security group headed by Mr. McCord had entered onto the premises of the Democratic National Committee at 2600 Virginia Avenue prior to June 17, 1972? Answer: I don't have that information to this date, except to read of speculation in the newspapers. Question: your answer is no. Answer: no. Question: now, beginning on June 17, 1972, and for the period thereafter, did you have conversations with anybody from the security group, etc.? That continues. But what you're telling me here today, Mr. Mitchell, is that you were notified of a prior break-in on either the 20th or the 21st of June, and that you denied such knowledge in a deposition taken on September the 5th,
Now,
1972.
let's go back on this, Mr. Weicker, because this is the same subject matter that you came up, and I'm glad that you read more of the information. I said that it was my recollection, and it could be wrong, that I had been advised of the earlier break-in, certainly that Liddy was involved. The questions, as you just read, relate to the security group of McCord, and it was answered in that context.
To me, it is very clear this is the same group that Mr. Liddy was involved with.
No, you'll have to read the rest of the transcript. Mr. Liddy was not part of the security group. Mr. Liddy worked for the Finance Committee, and the questions involved there had to do with the security group that was headed by Mr. McCord. This is a civil litigation, and I was not volunteering any information.
And Mr. Liddy, as a practical matter, was not a member of this group?
Of the security group?
That's right.
No, he was not.
The group that was involved in the breaking and entering?
No. Well, you'll have to go to the discussion of what was the security group, and it did not involve Mr. Liddy because Mr. Liddy worked for the Finance Committee.
Now let's move to June the 21st. At 8:15, you meet with Mr. Haldeman. At 9:50 in the morning, Magruder, LaRue, Mardian.
May I stop you, Senator?
Please.
That 8:15 is the regular staff meeting in the White House, just like all the rest of them are listed there.
At 9:50, you meet with Mr. Magruder, Mr. LaRue, Mr. Mardian, and Mr. Malik. At 11:30, with Mr. LaRue, 2:45 with Mr. Magruder, at 3:20 with Mr. LaRue and Mr. Mardian, 4:45, Magruder, Saddam, 6:20, Mardian, Magruder, and LaRue. Can you indicate as to whether anything in the discussion with Mr. Haldeman related to the Watergate?
Senator,
I know you've indicated it was a regular staff meeting, but that doesn't mean we still don't talk to each other.
There would have been no discussion of the Watergate at that particular staff meeting that involved the upper echelon of the people in the White House at that particular time, and I can recall no such morning meeting when any of the specifics of the details of the Watergate matter were discussed.
But in any event, and this is a dispute still to be resolved as to whether you received the information from LaRue and Mardian on the 20th or whether you received it on the 21st, by the 21st, you have been given what I will call the Mardian-LaRue briefing relative to Mr. Liddy's activities.
I won't say that it is actually the 21st, but I believe that according to this log that it was more likely on that date at that meeting that I have pointed out, because I have a very distinct recollection that they were the only two people there at the time.
And you've stated that you didn't tell the President of Mr. Liddy's activities because of the fear that you had that revelation of these matters to the President would result in public exposure of these matters by the President, and that would be harmful to his re-election campaign. Is that correct?
Yes, and I want to make sure that you understand that we were not talking about the Watergate. We were talking about the other matters that have been discussed here, the so-called White House horrors.
I understand that, and I must confess it's one of the few areas probably of judgment where I would agree with you as to which was the more serious situation. And I think the horror stories, probably in a political sense, were far more serious than the Watergate.
Thank you, Senator, for that justification.
However, in trying to protect the President by not telling him of these activities and thus preserving his status in the campaign, didn't you feel that there was a far greater danger far greater danger relative to Mr. Hunt and Mr. Liddy, and that it wasn't sufficient not to tell the President, but rather that something would have to be done relative to Mr. Hunt and Mr. Liddy.
Done to him in what respect?
That's what I'm asking you, as to whether or not you felt that it was sufficient to protect the President by not telling the President, or whether you felt a far greater danger existed with Mr. Hunt and Mr. Liddy running around the countryside in having the story that you were trying to suppress come to the surface.
Well, Mr. Hunt and Mr.
Wasn't there a far greater threat that Hunt and Liddy would expose these activities than the President of the United States?
Well, that was always a possibility. The fond hope was that they, of course, would not, because they were involved in them.
Well, what'd you do to prevent it?
What did I do to what?
Prevent it.
I didn't do anything to prevent them.
In other words, you took care of the presidential situation by not telling him.
That's correct.
And you took care of the Hunt and Liddy situation by just letting it run its course.
Well, Senator, if you will look at...
Because your next contact relative to Mr. Hunt and Mr. Liddy comes in September, quite a ways away, before you get involved with them again.
Senator, the fact of the matter is that the rationale is that Hunt and Liddy were involved in those other activities, and there was every indication or belief that they were not about to go and incriminate themselves in those particular areas.
So you did absolutely, even though having a deep concern over this matter, having been told the White House horror stories, and having a deep concern that this could blow the whole campaign right out of the water, even to the extent where you didn't go ahead and tell the President of the United States, you did nothing relative to the two people who, if they talked, could blow the whole campaign out of the water.
Senator, I've never talked to Mr. Liddy or Mr. Hunt. I never talked to Mr. Hunt in my life. Never talked to Liddy or any of their counsel. But obviously, as we know, that there were other people that did have that concern and did start at a very early date payments for support and lawyers' fees.
Were you one of those people?
No, sir, I was not. As a matter of fact, I have testified here that when the suggestion was made at the Mardian and LaRue meeting after they met with Liddy, Liddy suggested to them that it would be helpful if the Committee for the Re-election of the President might provide bail money for the ones that were, I presume then, in the jail, that I refused to go along with it and turned it down.
Now then, let's move to 22nd of June. And again, run through those logs. 8:15 White House meeting, 10 o'clock White House meeting, 10:50 Magruder, Mardian, and LaRue meetings. 11:15 Dean telephone, 11:20 Ehrlichman telephone, 4 o'clock LaRue, Mardian, and Magruder, 5:20 Kalmbach by telephone, and 5:45 LaRue, Mardian, and Magruder. Do you have any recollection as to what it was that you discussed with Mr. Dean and Mr. Ehrlichman?
I don't have any specific recollection. Of course, as far as Mr. Ehrlichman was concerned, I dealt with him frequently on matters that pertained to issues in connection with the campaign. I believe, if my memory serves me right, that June 22nd was the day that the Democratic National Committee filed its lawsuit, and I'm sure that they must have had to be subject matters of the conversations.
Did you ask them, either Ehrlichman or Dean, as to whether or not they knew anything about the Liddy activities, which at this point in time you had come into knowledge about?
Did I ask them what they
right.
knew?
Did you indicate to them that you knew about Mr. Liddy's activities?
There was a period in here, Senator, and it must have been within this time frame, that after I had been debriefed by LaRue and Mardian, that I discussed the matter with John Dean, and John Dean made aware to me the conversations that he had had with Gordon Liddy on the 19th of June. So there was a reaffirmation of some of the material. They weren't exactly the same stories, but there was a cross index of information.
All right, now the phone call to Mr. Kalmbach at 5:20. Recollection as to the nature of that conversation.
If you will look, Senator, you will find that the next day and the day after that and right through Saturday of that week, there were calls to Mr. Kalmbach, and those calls had entirely to do with Mr. Kalmbach being of assistance to my wife, who was then at the Newport Inn in California having substantial difficulties with some of the people that were out there with her.
But of course, the date which I'm referring to is not that weekend at all. I'm talking about June the 22nd.
I'm talking about all three of them. If you look on the 22nd and go right on through, that you'll find that I believe there's a call every day. Yes, sir. There's one on the 23rd. There's one on the 24th, which is Saturday.
And there was no discussion at all of money with Mr. Kalmbach?
None whatsoever. It had entirely to do with my personal problem.
Now then, moving to June the 23rd, Friday, were you aware that 2 days after you learned of what you call the White House horrors, a concerted effort by Messrs. Haldeman and Ehrlichman began at the White House to encourage the CIA to get involved at first by informing the FBI of CIA involvement in the case, and thereby to hinder the investigation?
I was not aware of the I was not aware of the activities that were being carried on over in the White House, either by Haldeman, Ehrlichman, or subsequently Mr. Dean.
You had no conversations with Mr. Haldeman or Mr. Ehrlichman during this period of time?
I may have had
about
the subject matter.
Activity.
I'm quite certain that that is my best recollection. I'm quite sure that I didn't.
And on that same day, June the 23rd, Hugh Sloan, in an effort to alert the White House of what he was learning about people's involvement in the break-in, was first counseled to get a lawyer by Mr. Ehrlichman and told by Mr. Chapin that he, Mr. Sloan, needed a rest because he was distraught. And no one informed you that an employee of the Committee to Re-elect the President was at the White House in this regard. Is that correct?
No, sir. As a matter of fact, I met with Mr. Sloan, as you will see, on the next day, on the 24th, and Mr. Sloan never even mentioned it to me at that time. He expressed no such concerns. In fact, all he did was undertake an argument with Magruder in the presence of Mardian and so forth as to the amount of money that he had passed on to Mr. Liddy. And this, by the way, is the only time that I met with Mr. Sloan subsequent to June 17th and his testimony with respect to the fact that he was brought in to see me before he was being interviewed by the FBI is not correct. That was the matter that were being handled by the lawyers.
Now, Mr. Mitchell, I think probably I know what the answer to this one's going to be, but to try to pull together these 3 or 4 days, is it fair to say that on June the 21st, 1972, when you learned of the potential revelations of the Plumbers' activities, which revelations you knew could be devastating to the President, that you and others began a cover-up that carried over to the White House in order to prevent any such revelations?
Well, the answer to it is that I certainly was not about to do anything that would provide for the disclosure of it. What others were doing on their own or in concert with others is the subject matter that they will have to testify to. I think what Mr. Dean has testified to, that he thought the cover-up had started on June 19th in connection with certain activities that he testified to at that particular time.
In other words, again, the nature of the activities that you discovered on the 20th or the 21st of June were, in your mind, sufficiently explosive to throw a presidential campaign off the tracks.
There's no question about it. I've testified frequently to that subject
And yet
matter.
the only action which you took as one of the President's closest advisors and also as the head of the committee to re-elect the President, the only affirmative action that you took was to say nothing to the President.
Well, I obviously had discussions with the other individuals involved here about the subject matters, and this is where I learned more of the horror stories from John Dean. But as to an affirmative, overt action, there was no other action that I took during this period of time.
Now, let's move through some other days here. At what time, let me ask one question, on what date did you leave as the head of the committee to re-elect the President?
Well, I met with the President on, was it June 29th? June 3rd. Yes. On June 30th, I had a meeting with the President to discuss the subject matter, and the conclusion, the decision was reached, and it was announced on July 1st.
All right, on June the 30th, your logs for that day indicate meeting with LaRue, meeting with Mardian, telephone call from Dean, telephone call from Haldeman, telephone call with Haldeman, meeting with Mardian, 11:45 meeting with Haldeman, and a meeting with the President, 12:30, and then at 4:30 a White House meeting. What was the reason for your having left the campaign?
Senator, I answered that question previously, and it had entirely to do with the conversation that I had with Mrs. Mitchell, sometimes on the telephone, sometimes through UPI, to the effect that if I didn't get out of the campaign, I wasn't going to have a wife any longer. And that's the reason why I left. That was quite well publicized, I believe, at the time.
I wonder if I might have put before us the calendars of late June, which would indicate your schedule just prior to your leaving the committee to re-elect the President, and the schedule in July after you had left the committee to re-elect the President. Let's see, June 1st. Late June, and before that, in the middle of June. That's the schedule in June. Now can we see July? with the exception of the 4th of July, I'd say pretty much the same schedule, wouldn't you, Mr. Mitchell?
I wouldn't think so. It was quite a different area of operation. If you will go back, and of course what you've done there is just list on all of these charts the meetings with certain people. But if you will go back and look and see the change of the nature of the meetings, the different groups that had to do with the politics of the campaign, these are not shown on there. All they're shown on your prior charts are the ones that are involved in your hearings here.
Well, let me read out your schedule and the individuals involved on that schedule of June the 29th, which is the last day that the next last day that you served, and your schedule of July the 6th. On June the 29th, you're meeting with LaRue, Mardian, Haldeman, Dean, LaRue, Mardian, and Dean, either person or by phone. On July the 6th, Colson, Mardian, LaRue, Magruder, Haldeman, LaRue, Mardian, Dean, Magruder, LaRue, Mardian. Certainly doesn't indicate to me, does it,
Senator, you've just
change in pattern?
You've just picked out 2 pages that happen to coincide. If you go back and read some of these other pages, that you can see that I meet with all types of people, from campaign chairmen to senators and governors and all the rest of them on down the line.
My point is, Mr. Mitchell, that the burden of work, as far as you're concerned, does not change.
It changes completely. Clark McGregor came in and took over the running of the campaign and met with the type of people that I'm telling you about, except in some specific areas that remain for me to look after in my consulting role.
Did anybody discuss the fact, Mr. Mitchell, that the reason why you should leave as the head of the committee to re-elect the president, it might be considered that in that capacity you were subject to the daily confrontations with the press, and which press might go ahead and continue to ask you questions relative to Watergate? Was this ever discussed?
If it was, it wasn't discussed with me, no. The determination, Senator, for my leaving the campaign was made entirely on the basis of that luncheon conversation that I had with the president.
July the 1st, Saturday, 9:40, you meet with LaRue and Moore and Magruder. 12:08, LaRue, Magruder. 12:20, Kleindienst by telephone, and then from 5:13 to 5:36, and it does not appear on your logs, you have a phone conversation from the president from San Clemente.
Yes, I had a phone conversation from San Clemente, which I have described to this committee. And obviously the phone call came to my apartment, since the log here shows that I left the office at 2 o'clock.
And this conversation was on the evening of July the 1st, is that correct?
That is correct.
Did the president call you the next day, July the 2nd?
That is also correct.
Do you know where he called you from?
According to the information that I've received from the White House, he called both occasions from San Clemente.
What time?
What time?
Yes.
And
insofar as the call on July 2nd is concerned.
July 2nd, the information provided from the White House switchboard shows that the time was 9 a.m. And I don't know whether...
My information shows 6 a.m. on Sunday morning.
Well,
The time difference.
we had the discussion yesterday, I believe, as to the time difference, and I'm not quite certain whether this is Washington time or San Clemente time.
On July the 11th, you meet with Fred LaRue at 11 o'clock in the morning, and then at 12:48 have a conversation with the president, which again does not appear on your logs.
It's 12:43. It shows here that there was a call, and it is not in the log, and I have no explanation as to why it isn't.
Do you have any ideas to the substance of that conversation?
Now, which one are we talking about, Senator?
We're now talking about the conversation of July the 11th.
To the July of the 11th conversation, to the best of my recollection, as I testified yesterday, had to do with the discussion of the President's determination to keep Vice President Agnew on the ticket, or at least to recommend him to the convention that he be kept on the ticket.
And then after that phone call with the President, you meet again with Mardian and LaRue, is that correct?
Well, there's obviously no relationship to it because I wasn't discussing with Mardian and LaRue the President's desire to keep the Vice President on the ticket.
Well, let me give some examples of pattern, again, so that you can possibly supply me with an explanation that I failed to get from the logs themselves. June 30th, you meet with LaRue at 9:35 a.m., with Mardian at 9:45 a.m., with Dean at 10:30 a.m., with Haldeman at 11 a.m., and then you talk with the President at 12:55 p.m. July the 21st, you meet with LaRue at 10 a.m., with Mardian at 10 a.m., with Dean at 10:15, with Haldeman at 1:15, and then with the President at 2:01. July the 27th, you meet with LaRue at 9:35 a.m., with Dean at 12:50 a.m., with Mardian at 1:10 p.m., and you talk with the President at 5:51 p.m.
Senator,
there's no connection. What you're telling me is none of the matters that were discussed as between you, Mr. LaRue, and Mr. Mardian were discussed with the President.
I'm telling you that as affirmatively as I can put it. No question.
Did you discuss them with anybody else?
Discuss what, Senator?
Matters that you and Mardian and LaRue, specifically, I imagine these were Watergate matters, is that correct?
All aspects of it, Senator, including the civil litigation, including, and this runs on through to the General Accounting Office inquiry. It has to do with the currency problems that were involved. It has to do, of course, as you can see from many of these meetings, with a response to the charges that the Democrats were making.
One thing relative to the logs, and then we'll leave them. It is possible, however, as far as your logs are concerned, since we've established the fact that calls, meetings with the President that appear on the White House logs do not appear on your logs, that there very well might be other meetings with other individuals that do not appear in your logs. Is that correct?
Senator, it's always conceivable, but I doubt that that would be the case because of the manner in which these logs were kept, and I'm sure the staff has interviewed my secretaries, and they'd be much better able to describe that than I would.
Well, if a presidential phone call doesn't impress them, I'd imagine not much below that's going to go ahead and impress them.
I think both these girls were quite accustomed to receiving and handling phone calls from the President, and I think that they might have had many, many more of them before this period of time, as my earlier logs would show.
But it was customary not to have them logged?
No, sir, it was not. As a matter of fact, my logs, as I testified yesterday, were started in the Justice Department, and they were continued even beyond my knowledge after I left the Justice Department in the same form, shape, and circumstance after I came to the practice of law, and then subsequent that to the committee.
Now, on March the 22nd, you stated that you spoke with the President along with Dean and Haldeman and Ehrlichman, and that the sole subjects were executive privilege and developing a liaison with the Select Committee. Is that correct? And that nothing else concerning Watergate was discussed.
I said that those were the main topics of the meeting. There was also the discussion, as I said, of having somebody provide liaison with the committee up here. Dean was discussed, and apparently rejected, and then Ehrlichman, and as I think the record will show, and I think I can bear out Mr. Dean's recollection of it, that the President called Mr. Kleindienst on the subject matter while we were there.
Everybody seems to be very much in tune with the conversations of that particular meeting. And yet, in the President's remarks of April 17, 1973, he states, on March 21st, as a result of serious charges which came to my attention, some of which were publicly reported, I began intensive new inquiries into this whole matter. That is by the President's own statement. On March 21, as a result of serious charges which came to my attention, some of which were publicly reported, I began intensive new inquiries into this whole matter. And on March 22nd, you and Mr. Dean, Mr. Haldeman, Mr. Ehrlichman all meet with the President, and the subject matter of Watergate never comes up. Is that correct?
Now, what part of you talking about Watergate? We're talking about this committee up here whose purpose was to investigate Watergate, as I understand it. So obviously, the subject matter of Watergate came up in connection with this committee, being the committee to investigate Watergate. But if you're talking about, did the meeting have any conversations that went back and reviewed the bidding as to who did what to whom under what circumstances, the answer is no, it did not.
But we know from the President's own statement that on the day before, new inquiries were made into the whole matter. And here he has standing before him, following day, the head of the committee to re-elect the President. Any inquiries made? Did all of the former head of the committee to re-elect the President?
No, sir. The conversations were just as I have reported them.
So, in effect, no question, even though the President stated that new inquiries were being made, no inquiry was being made of you by this particular group of gentlemen, either the President or Mr. Haldeman or Mr. Ehrlichman or Mr. Dean, in that room at that time.
There was no such discussion, Senator.
Do you find that surprising in light of the March 21st statement?
I find it surprising in light of what Mr. Dean said about the March 21st conversation that he purportedly had with the President.
I'm not talking about Mr. Dean. I'm talking about what is reported as was said by the President.
Well, what date of that statement, Senator?
This is the statement of April 17th, 1973.
Right.
And the statement says, my second announcement concerns the Watergate case directly. On March 21, as a result of serious charges which came to my attention, some of which were publicly reported, I began intensive new inquiries into this whole matter. Last Sunday afternoon, the Attorney General, Assistant Attorney General Peterson, and I met at length in my EOB to review the facts which had come to me in my investigation, and also to review the progress of the Department of Justice investigation. I can report today that there have been major developments in the case concerning which it would be improper to be more specific now, except to say that real progress has been made in finding the truth. That is the President speaking on the relative to what he did on March the 21st.
Now, what question would you like me to answer?
My question to you is, do you find it surprising that when you appear on the scene on March the 22nd, since sweeping new investigations are being made, that nobody goes ahead and raises the Watergate insofar as any participation of those in the room? Do you find this rather surprising?
I don't.
Considering the new attitudes toward questing for the truth announced or started on the 21st of March.
Well, I would presume that the President, under a normal process, would be having others look into the matter and not the President himself. I'm sure he has a lot more important things to do than to conduct an investigation of his own of that type.
Or do you think it's possible? In other words, it doesn't surprise you that nobody discussed Watergate. I'm talking about now, I'm not talking about the committee. I understand all about those discussions that go on about the committee. I'm specifically talking about the involvement of persons in that room. It is not surprising to you that it was never discussed in light of this statement of the President.
No, it doesn't
where
surprise
no
me.
affirmative action was being taken just the day before.
No, that wasn't the purpose of the meeting, and I can understand why it might not have been discussed. As I say, there may very well have been somebody else who was conducting the investigation.
Do you think one of the reasons that it might not have been discussed was that there was no point in discussing it with the people in the room because nobody was going to gain any knowledge from that meeting, that they already had that knowledge?
No, I hadn't thought of it in those concepts, but I don't believe that would have been the case. When you meet with the President, you meet with the President for a specific purpose, and the purpose was the purposes were as I have stated them here.
Well, now, the President already knew at that point in time, or suspected, let's put it that way, suspected, that you were involved. Dean had told him this.
Well, now,
and you don't find it surprising that he doesn't turn to you and say, John, for heaven's sakes, would you please tell me what your involvement in this matter is?
Senator, are you taking that from John Dean's testimony? Is that where you're getting that?
I'm taking this from the White House logs, Mr. Mitchell.
The White House logs of what? What is the White House logs?
Of the meeting with John Dean, between John Dean and the President.
And what does it say about Mitchell? I'm not privy to those logs.
Dean gave the President his theory of what had happened. He still said no prior June 17th White House knowledge that Magruder probably knew, that Mitchell possibly knew, that Strawn probably knew, that Haldeman had possibly seen the fruits of the wiretaps through Strawn, etc. Your name came up in the conversation. It had been bandied about.
This is still a Dean allegation. Well, Senator,
this is the White House version.
Senator,
this is the White House version, Mr. Mitchell, of the meeting with John Dean.
I understand that, but it's still John Dean as being the one who's being quoted.
Well, why did you find it unusual that the President didn't ask you on March the 22nd to comment upon Mr. Dean's conversations with him as they related to you?
I didn't find it at all unusual because of the basis.
You don't find it unusual now because you didn't know anything then. You don't find that unusual now?
I don't find it at all unusual because the basis of the meeting and the purpose of the meeting was a different one, or different ones, as I've stated.
Is this your definition, by the way, this kind of testimony? What is the expression of stonewalling it?
I don't know that term. Is that a Yankee term from Connecticut?
Now, Mr. Chairman, I'm going to ask one more question. I really do have another series, but I won't take the time of the committee now. But there is one question that I would like to get into. Relative to the question of Now, you've referred repeatedly to the White House horrors. Specifically, one of the horrors, I believe, is the break-in into the office of Dr. Ellsberg's psychiatrist.
That is correct.
That is one of the horrors. And on or about June the 21st, is when you found out about this.
That is correct, Senator.
You're no longer Attorney General at this time.
That is correct.
But you are an attorney. Is that correct?
That is correct.
And you're an officer of the court.
That is correct.
Did you bring this matter to the attention of any law enforcement officials?
No, sir, I did not.
Did you notify any officials in the Justice Department about the break-in?
I notified nobody about the break-in.
Did you notify Judge Byrne, the judge presiding in Ellsberg's prosecution, that you knew about a break-in of the office of his psychiatrist?
I notified nobody about the break-in.
In other words, as an officer of the court and as a former Attorney General of the United States, you were content to remain silent, even though you knew that silence might possibly convict an American citizen via means of illegally or illegal conduct.
Senator, I'm sure that you're aware of the fact that that break-in produced nothing whatsoever, and under no circumstances could there have possibly been any fruits of the break-in that could affect the trial one way or the other.
It's not really a question of what they found, is it, Mr. Mitchell?
In answer to your question, it is. Your question was whether or not an American citizen could have been convicted because of this act. And I'm saying that as I understood the story as it was related to me, there was no material obtained or used. Since it hadn't been obtained, it couldn't have been used.
You didn't know that at the time you committed the act?
I didn't know the time they committed the act. I'd heard it when I was advised of the nature of the break-in.
What I'm saying to you is that you had no way of knowing at the time that you remained silent this man might not have been convicted. Through information that you knew had been illegally obtained.
What I am saying is these stories dribbled out and were embellished upon. It became known to me that their entry was unsuccessful in obtaining any information out of the doctor's office.
Is there anything in this country, aside from the President of the United States, that puts you into awe, Mr. Mitchell?
To put me where?
That puts you in awe?
There are very, very many.
Do the courts put you in awe?
Very much so.
Does your oath as an attorney, does that put you into awe?
Very much so.
Do you feel as an officer of a court you did the right thing?
In connection with the Ellsberg matter?
When you did not notify the prosecution, or you did not notify, rather, Judge Byrne of the information that you had in your possession?
I think in retrospect it probably would have been the right thing to do.
I have no further questions at this time.
It's a great trial they're conducting up here, isn't it?
The committee will stand in recess until 2 o'clock tomorrow.
Yeah. I'll be right.
Don't forget that.
Hands off.
How are we going to get everybody?
John Mitchell returns tomorrow to continue his testimony. Several committee members want a second chance at questioning the former Attorney General. The debate continues over whether Mitchell can be shaken from his prepared story, told in a monotone, if possible. So far, Mitchell has kept his cool. But again today, like yesterday, there were indications that some of the questions were getting under his skin. And Mitchell's closing remark in today's testimony indicates that things haven't gone as smoothly as he would have liked. When the committee completes its questions with Mitchell, the next witness will be Richard A. Moore, the California television executive who's been a special counsel to the president since 1971. Moore could corroborate some of John Dean's testimony about the decision to tell the president the cover-up was at an end. But first, the committee must solve the mystery of the man who didn't tell the president about the implications of Watergate because he was afraid Mr. Nixon would fire the guilty and thereby jeopardize his own re-election chances.
A political expert and a legal expert watched John Mitchell's day number 2 with us today. They are David Epstein, an adjunct professor of law at the Georgetown University Law Center here in Washington and a former prosecutor in the U.S. Attorney's Office here, and Stephen Hess, former aide to President Nixon, an author on political subjects, now a senior fellow at Brookings Institution. Mr. Hess, obviously it must have been the Baker questioning that struck you the most about today, right?
Right. I found that Senator Baker asked some exquisitely important questions. They weren't those questions about contradictions or facts. They were really questions about judgment or even theory. Basically, I think what Senator Baker was asking is, how does our governmental system assure that presidential-level decisions are made by presidents? The problem is, as John Mitchell stated it, was that there are so many decisions to be made, and often they're very mundane ones. But we at least should have the feeling that the president is making the great decisions. Yet we've found that people other than the president often choose what those decisions should be that are brought before the president for decision making. Here in the case of the Watergate, if we're to have the sort of hindsight that Mr. Mitchell keeps talking about, it's become increasingly clear that President Nixon was seriously misserved, that there were decisions that were being made by Mitchell and apparently by others to deliberately limit his information, if we are to believe what Mr. Mitchell has told us. Now, he may have done this out of some misplaced concept of loyalty, but nevertheless, he arrogated for himself decisions that should have been made by a president, and he did so in what he thought was the president's own best interests. So now, in my opinion, this is perhaps the most charitable interpretation that can be placed on the facts that have been revealed to us by Mr. Mitchell so far.
David, this applies not only to the president, it also could apply to a cabinet officer, right?
Well, Mr. Mitchell didn't go into that, but that would be the question that I think would be most interesting to ask him. Did he, as Attorney General, have this doctrine of selective executive information? Did he advise his subordinates that any matters that were politically embarrassing that he should not know about, that he shouldn't know about? Did he have this idea that there's certain information that's too hot to handle at the top and is better taken care of at the bottom? And the question is particularly important with respect to the Attorney General, because here's the person who has enormous discretionary powers to decide whether or not to investigate in a particular situation, to decide whether or not to institute a prosecution in a particular situation. And during the course of the testimony, Senator Ervin made reference to the politicalization of the Department of Justice. He suggested that taking a man out of being a campaign director, as was Mr. Mitchell, and putting him into the Attorney Generalship, or even earlier when President Kennedy took his brother, Robert Kennedy, and made him the Attorney Generalship, also coming out of a purely political background, made the Department of Justice even more subject to this kind of weighing of enforcing the laws, but on the other hand, keeping in the back of your mind the fact that there are political consequences. And I'd be interested in hearing Steve's views on can you or should you take the Department of Justice out of politics altogether, and if not, to what extent can you insulate it?
Well, of course, David, it's not just the Department of Justice that deals with political concerns. It's every department of government, the Agriculture Department, Labor, Commerce, and so forth. There's a simple answer. If you want a simple answer, you can always further expand the civil service and therefore depoliticize the federal branch of government. But we probably have, what, 3.5 million civilian employees in the federal executive branch. Maybe 2,800 now are political appointees, those appointments that a president makes when he gets into office. So quantitatively, at least, we can say that the federal bureaucracy is hardly over-politicized. But what bothers me is an assumption that we constantly make that politics is somehow a purely corrupting force rather than the way that people mandate their government. After all, the president is the only member of the executive branch who is elected by the people.
And thus accountable to the people.
That's right. And I always worry about suggestions that further remove the citizen from the right to affect the decisions made by the government. And this is the balance that we have to worry about. We must be very careful when we have these awful events like Watergate, and so the pendulum swings far back in the other direction.
And that, of course, is one of the basic things that everybody has said that's come out of Watergate, is its repulsion to anything that has to do with politics, et cetera, et cetera. Gentlemen, thank you very much.
Mitchell faces more questions from the committee tomorrow. After today's session, NPAC's Peter Kay discussed his performance so far with Ranking Minority Member Howard Baker.
I think Mr. Mitchell, by and large, has made a rather thorough presentation. He has presented, I guess for the first time, substantial conflicts now on the record. At some point, we'll have to try to reconcile those if we can. If we can't reconcile them, try to find out where the truth lies among the conflicting pieces of testimony. But Mr. Mitchell was a stalwart witness, a thorough witness, and he certainly was unflappable. But beyond that, I really think that the discipline I've imposed on myself to refrain from commenting on the quality or the relevance or the believability of any witness's testimony ought to preclude me from saying more.
Let me ask you this way, that during your own questioning, you brought out what I think could fairly be summarized, that Mr. Mitchell believed that in essence the end justified the means, that the re-election of the president came before the so-called disclosure of the White House horror stories and the Watergate incident itself. A lot of people were wondering just why the next step wasn't taken, why the question wasn't asked, well, if these stories were true and if you believed them, then wasn't it necessary that that came out? And just what would turn you off? What would make you say, whoa, that's enough?
Well, I did ask that, if you recall, and I think the only example Mr. Mitchell gave when I put it, how far does it have to go? Where's the crossover point, so to speak? And he gave us examples, treason, or, as he put it, I believe, high crimes and misdemeanors, which are the constitutional phrases that deal with the impeachment process. But that's not very specific. In any event, it was clear from the Mitchell testimony, and I don't believe this does violate my self-restraint. It was clear from the Mitchell testimony that he claims he did not know of the events before they happened, that he did in fact know of them shortly after the middle of June, and that he was determined not to tell the president. Now, that is the burden of the Mitchell testimony. What I was reaching for was, why didn't you tell the president? How do you arrogate unto yourselves a presidential-level decision, that is to say, whether to proceed in one manner or the other when you come into possession of these facts? And as you know, we went around the maypole a good bit about that, but we never quite established a record with a definitive statement on it.
Based on my own reactions at this late hour, I would be very suspicious of anyone who would attempt to neatly judge John Mitchell and his testimony. His total performance thus far conjures up uneasy feelings of puzzlement, bewilderment, confusion, rather than absolute certainty. For instance, he denies that he was a major participant in any of the serious wrongdoing. It was all those other people, the Liddies and the Magruders and the Deans and the LaRues and possibly the Haldemans and the Ehrlichmans. And yet it is very clear that John Mitchell is no patsy, far from it. He's a tough guy who makes decisions and runs things, including the little people under him. Then there's that crucial business about his not telling the president everything he knew. It's hard to believe, isn't it, to be very blunt and frank about it. After all, these two men, Richard Nixon and John Mitchell, were very close friends, personally, professionally, and politically. There is no evidence that any one man has ever been closer to the president, in fact, than John Mitchell. Mitchell wants us to believe, however, that he never breathed a word to the president about Watergate, and even more startling in many ways, that the president never asked him a single question after June 20 about what really happened, who was involved, or anything like that. There are many other instances of this sort. Mitchell asking us to shake off any obvious doubts and go with his version. It's a difficult thing to do, extremely difficult. And yet, while all of the doubts and the questions fly around, there is that solid, rough manner and sound and gesture and of honesty and candidness about this man, John Mitchell, that makes you stop and say, well, now maybe it just could have happened the way he says it did. Well, as I say, it's all rather confusing, to me at least. We'll be back tomorrow with day number 3 of John Mitchell. For Robert McNeil and Peter Kay, I'm Jim Lara. Thank you and good night.
From Washington, you've been watching gavel-to-gavel videotape coverage of hearings by the Senate Select Committee on Presidential Campaign Activities. This coverage is made possible by grants for special events coverage from the Corporation for Public Broadcasting and the Ford Foundation, and has been a production of NPACT, a division of the Greater Washington Educational Telecommunications Association.